Hello, everyone. Welcome back to the Human Responsibilities Tribunal and the Riff Raft. It's just me today, Limina. Sorry, David couldn't make it. He's still recovering. I want to thank everybody for joining me on that last panel podcast where we discussed misconduct, both with the University of Alberta and the Alberta government. And what's come from that panel discussion is a recommendation that me and David, so just me, talks to this fella, Matt, who's having his own issues with the federal government of Canada. And so I thank Gilbert for the recommendation to have Matt on our show. I really appreciate it. If anybody else has any recommends, let us know. We are always interested in speaking to people who are willing to take on and do things for themselves. And this guest is just a powerhouse of the things you think you might not be able to do for yourself, but you can. And so welcome, Matt. So let's talk EI, one of Canada's great institutions like their public health care. EI is something that all Canadians pay into, and it protects us and is part of the Canadian social safety net so that if we get pregnant, if we lose our job, if we become unwell short term, that we are protected and our income will be provided to us through the premiums and by the premiums we've paid to the Canadian government, and we will be protected and therefore one thing, we wouldn't have to be on another Canadian social safety net called welfare. We will be protected and our income is insured. It's a collective public insurance program for, it used to be called UI, now it's EI, employment insurance. So it's one of those great Canadian institutions, one of the great Canadian social safety nets, and we all love it, right, Matt?
We did up until the pandemic, yes.
I'm not sure we did before that, but I'm old, you're younger. So tell me, what happened?
So I guess a lot of this is rooted around the pandemic. And
okay,
just to set the stage, we've been very clear in this EI case that we are not dealing with the reasonableness of mandates and things like that, because most people who try and make those arguments, even if they're fair arguments, get told, sorry, we're not medical experts. Sorry, we can't do this. We can't do that. You're denied. So we did something different, and we looked at how does the EI law work and how is it supposed to be applied historically going back several decades. We did an analysis since the 70s.
Okay.
And I guess the short elevator pitch until we get into it is about 450,000 people were denied employment insurance for non-compliance with the mandates. And it's very clear in the Employment Insurance Act that if your employer is acting contrary to law, or if they unilaterally change your employment contract, then you qualify for EI. And that decision was made hundreds of times in the 6 years before the pandemic. The problem comes when you have close to 500,000 people applying in 3 months. It's $12 to $13 billion. It would have collapsed the EI pool of money. And they're not allowed to borrow money to subsidize it. So they had to find a way around, how do we keep this program solvent? So they engineered in secret new processes that coerced decision makers to break the law by denying benefits when they were entitled to it, using all sorts of shenanigans, pre-written decisions, and we can get into it as we go on. But that's the root of it. And our challenge is, hey, the law is the law. If you want to change it, preserve the program, you can do that. But if you're not going to, then you can't just engineer processes that force decision makers to break the law on your behalf to try and keep the program solvent. So that's the basis of our challenge.
Yeah, and I just so for anybody outside of Canada or in Canada who doesn't actually understand programs like EI or programs like our public health care or even our CPP, they aren't just pie in the sky programs. They follow an act. So the first thing for any of these programs to come into place is legislation is written like the Employment Insurance Act, which is a piece of legislation that would have gone through our parliament, been accepted, and then placed into law. From that is what the program surrounds. So the program is basically its first set of policies is legislation here through the federal government, right?
Yep, and decision makers are bound by it. So in Canada, the Supreme Court has made it clear the reason why courts are supposed to defer to the decisions made by EI decision makers is precisely because they're getting their authority from Parliament. So as long as they're following the law, courts are not supposed to disturb their findings. However, when you engineer processes that break the law, now they've got a bind, right? What do you do? When the law says they qualify for EI, internal processes say, no, you have to deny them. And here we are.
And we've heard a lot about that through not just the public systems, but the private systems. That delay, deny, and defend thing is real, and it is a tactic, right? It is a tactic. Unfortunately, when you're dealing with an entity that is also public, that has a legislative background, they can also just rewrite the policy, right? There's no law they won't make and no law they won't break now because they're in charge of that. So on top of deny, delay, and defend, you also have I can't think of a great alliteration that starts with a D. Maybe you can, but you can change the legislation, or you can change the policy of the legislation. Or some of these legislations are so ambiguously, and I think purposely ambiguously written, as to they could mean anything depending on where the sun is setting that day.
Yeah, discretion. That's been their argument to use the D word, is they're trying to say that we have the discretion to operate the program. So we're going to make internal changes, which is, that's what the law is set up for, provided those discretionary policies don't break the law. That's what happened during the pandemic, not just in EI, but en masse, right? Is new discretionary processes were weaponized that broke all sorts of laws, and we're just supposed to accept this discretionary use or arguably misuse of Crown authority.
So I suspect there's more than one discretionary rewriting that happened to push people out of this program or make them ineligible. Let's start with one that's really precise and really easy to see and put it in a time frame that we can understand.
Okay.
Yep.
Let me pull up my slides here.
And let me preface this while you're pulling up your slide, if you don't mind, Matt, is that these weren't done out in the open. These weren't done like your auto agency that's saying, hey, we're making some changes to your auto policy. You're now going to be charged X. These were done in secret and people didn't know till they were in the face of it. Is that right?
Yes.
Okay.
Yeah, I'll start the BE memo. That's, to us, one of the most egregious ones.
Sure, I'd like to see it. I really like, Matt, that you've brought a lot of receipts to that, because I find, there's a lot of, well, not a lot, but there's talk, right? And on social media, everybody's big talker, but nobody actually brings what we need to see to validate it. We're living in a time of bullshit, I think, where we don't know what is true and what is not. So one of the things I want to point out to people watching here today is that they can look up any of these documents or you've provided them here as well, and they can find them on your website. So I've got the tiny URL here for the public interest part. And in the show notes, there's a link to everything that Matt's talking about here. Along with seeing them today, I highly recommend that people investigate further because this is a huge complex issue and there's only so much we can get to today. We are going to have Matt hopefully back in March after his court case, but for now that's where we'll start. So let's look at the first secret rewriting of the EI program.
Okay, I have slide 11 marked. Can you pull up the slideshow?
Yes, I can. There you go.
Thank you. I'm just going to make it full screen on my end. So this here is the process for employment insurance. Can you see my mouse?
I don't think so.
Moving around?
My eyes are bad. No, I can't.
Okay.
We've just changed slides. There we go back. Can you see my mouse?
No. So
No?
we'll do it this
Okay.
way. Can I share my screen? And then by sharing my screen, then I'll make sure that my mouse shows up.
Sure. Let's I just want to remind everybody to please be patient with us because actually it's really important. This is so intricate and just like my panel show that it's important we get it right so people have the accurate information. So just be patient as we figure this out to make sure. There you go. I think you're good there, bud.
Okay. So I've got my, can you switch to the screen sharing?
I think it is. It's on there. I can see it.
The slideshow.
Okay. So there's two showing up. There you go. I've seen yours.
Yeah, it's the one that says.
Is that right?
Justice.
Like I just saw. Yeah, I just saw.
Now you should be able to see my.
Yep, I can see it. There you go.
You can see my mouse now?
Yep.
Okay, beautiful. So I'll make this full screen. So this is the EI claims process, and it starts. I pulled this off of the Social Security Tribunal website. So there's 5 phases. 1 to 4 is how they're labeled. Phase 0 is what happens inside the employer. So you're at work, something happens that causes you to be separated from your employment for anything. It could be you quit, you could have been fired for cause, it could be pregnancy leave, or any number of reasons. And they have to issue a record of employment to the government that explains what is the reason for you leaving. And it's important to note that that record of employment is the only sworn evidence through this process to the tribunal. And it's actually a criminal code offense. If you put the wrong code on there, there's warnings. Box 22 on every form says, I recognize that it is a criminal offense to misrepresent the reason for issuing this form. Then you come into Service Canada, which is part of Employment Canada, the department. And Service Canada, here in 1, will give you a decision. If you don't like it, then you can appeal internally, and they have something called the EI Commission, which is an arm's length agency inside Service Canada. So you have your baseline and your appeal. If you don't like it, then they send you to the Social Security Tribunal, which is an entirely separate agency. And as you can see down the middle,
I've dealt with them before, that CPP one. Yeah, interesting. Okay.
Yep. And we're going to make this slide deck available. As you can see, everything that's orange is linked. So you can see that each step along the way, there's laws that restrict or direct how they are supposed to decide your case. And then inside the Social Security Tribunal, there's also 2 levels. There's your general division and your appeal division. If you're
Okay.
still unsatisfied, then you can apply for judicial review inside the federal court system. And we're at the very end of that now. We're at the Federal Court of Appeal, which is the last stop before the Supreme Court. And the Supreme Court has never taken an EI case. So for all intents and purposes, this is the end
Really?
of the road for us.
Okay.
So I want to look at what happened inside Service Canada. First, sort of engineering, that's important. And I will pull up the document in a second. We have ATIP, so everything is sourced. This memo is called the EI Eligibility and Refusal to Comply with Mandatory Vaccination Policy. And it starts right off the bat by saying this memorandum is not linked to any legislative or regulatory amendments. So there's their legal cover. Right in this policy, they're saying we're going to change how you adjudicate EI cases, but we're only going to apply this policy to a specific subset of Canadians, not everyone. And we're telling you, you have to follow this policy, but it's not linked to any legislative or regulatory amendment. So this is not legal. This is a discretionary use of our policy. And in this policy, an important side note is this policy was not published to the public. That's very important because the Supreme Court has said that it is unacceptable for decision makers to expect their decisions to be upheld on the basis of internal records that are not available to that party. They issued this new policy that was binding, that only applied to a subset of Canadians, and didn't release it. And this policy was egregious. It changed the definitions of things that are established by law. For instance, fact-finding. Both the EI Act and the policies for EI say that you have to consider things like contracts when you're adjudicating a case or deciding it.
Okay.
In this policy, they changed the definition, and I'll pull it up where it says complete fact-finding means, and they gave a new definition that overrode what's in the law. They changed the definition of terms like suspension or dismissal. They changed the terms of leave of absence. How do you qualify? They overrode medical and religious exemptions. So for instance, prior to the pandemic, if you're applying for a medical exemption, you're getting a doctor's note. They changed it, and in this process gave discretion so that an employer can just say, yeah, we don't think your religious beliefs are sincere enough, so you're denied. Or we don't think your doctor has the right decision. And all of a sudden they're overriding the professional opinion of a doctor or like from your religious institution if you get a letter from them. So I'm just going to quickly pull up.
Can I just cut in there too? One of the things that really strikes me too is they're interlocking pieces when we come to these government with the mandates and what have you. It's not just that that they've changed these definitions or that they won't take a look at what your doctor said or you're not religious enough to get the religious exemption. I mean, interlocking with that piece of those changes was the freedom of religion got degraded in the Charter of Rights and Freedoms, and then the professional body of the doctors said you're not actually allowed to write letters anyway. You're not actually allowed to give somebody an exemption. So you know, we're talking about this one piece, but I want to remind people that there is other interlocking pieces that also put pressure on people that made, even if they didn't get, let's say their appeal didn't work or they were denied EI, their EI actually claim could have actually stopped at the doctor when they went to the doctor and said, I need an exemption to get out of this and then collect my EI, and the doctor said no. You know, so the people affected by this EI change are bigger than the ones that was just denied, right?
Yeah, that's
if that makes sense.
That's one of the fundamental things we're arguing, is that this was engineered. There were processes that were engineered across multiple agencies, across multiple government departments that interlocked. And I mean, that's really hard to stumble upon by accident. And we're not upset with the decision makers who denied us, because they were just, we were coerced, right? Take the shot or lose your job. They were coerced. Use these new policies or lose your job. So what we're trying to do is expose how processes were engineered across the board. Just as a quick side note, this is our homepage. It's justiceforeimisconduct.com.
Yeah.
A lot of our arguments are listed here.
Yeah.
All the source documents. So for the BE memo, this is all of our argumentation we're submitting to the courts with the quotes. We're going section by section. At the bottom, you have all of our sources. So we have the affidavits that we use to obtain the documents. We have the BE memo itself. So all this is publicly available. We want everyone to see. And as you can see, the little stamp up here, this proves it actually came from the privacy commissioner. We didn't find this on some group channel somewhere.
Okay.
So this document walks through the EI process step by step and changes definitions of voluntarily leaving. They change what suspension or dismissal means.
So can you walk me through one of those so we can understand how profound the changes are? So when you say it changed what voluntary or involuntary leaving meant, what was it before, and what did this change to?
Okay, so we'll deal with fact finding. I think that's one of the worst ones.
Okay.
So the decision maker is responsible for ensuring that fact finding is complete before making a decision. And again, this document only applies to a specific subset of claimants. It says that it doesn't have any force of law, and yet at the bottom, they're told that
You're cutting out a bit there. Can we go? Sorry, we cut out there for about 5 seconds. Can you come back? Can you go back about 5 seconds?
To here?
Yeah, there you go. Thank you.
So yeah, we're showing how they're saying that these cases will be sent to the service desk, which is their management staff involved in processing claims. Let me zoom in a little bit.
Okay.
Have to follow this. And if you have, so for fact finding, they're saying this is what fact finding means. You see the quotations here? Complete fact finding means that all facts necessary to make a sound decision have been obtained and are included.
Okay. But
something. The answer is yes to each of the following questions. The fact finding is sound. So this is a comprehensive list, right? This is the only thing you need to have is certain elements on file. So is the policy on file? Was it communicated?
Yeah. Mm-hmm.
Did you deal with religious exemptions? So if we go back to the law, Act, show it this way. Hanley always takes too long to load.
Yeah, that's all right.
Section 51. And I'm going to pull up.
I think people don't realize how dense these legal acts are. Like just trying to watch you pull up one thing from this Employment Insurance Act it's almost painful. Not that you're doing a bad job. It's just I know that I went through the FOIP Act of Alberta, and it's hundreds of pages, right? To try and understand these, they're just dense legal documents, and that doesn't include like the policies on how they're laid out or how the bureaucracy is maintained.
Okay, so here is the EI Act, Section 51. This is in, I can blow it in a second, but this is the section on information.
Okay.
If in considering a claim for benefits, the commission finds misconduct. That's the key, right? They're saying that we refuse to comply with the policy that our employer denied EI. The commission shall give the claimant an opportunity to provide information for the reasons, and if the information is provided, take it into account. So if they're going to deny you for misconduct, they have to give you a chance to provide information, and they must take it into account. So if we go to their policy rules, this is their internal policy they have to follow. Section 21 is called evidence or proof.
Okay.
And we're going to go to evidence defined. And you're going to see twice in 2 places
So again, what we're on right here with Matt is the actual Government of Canada, a federal website, and we're on the actual employment insurance benefit entitlement section. If you want to see a shorter version of this, there's some clips actually, got the banner across. There's some clips that's provided in a shorter, maybe more punchy version on Matt's website.
Yes, thank you for that. We have about 30 short 2 to 5 minute clips, which I'll get into. We also have about a 2.5 hour podcast that was broken up into 15 to 20 minute sections by topic.
Yeah, okay, yep, that's great.
Here's the policy for gathering all available evidence. Because evidence is any information that tends to prove or disprove a point, it can take many forms, such as any written instrument, including documents, records, letters, notes, contracts, and collective agreements. You go down just a little bit further, and documents and records, and again, you see employment contracts, collective agreements, also the labor laws are part of it.
Okay.
It says here, these are the methods available to amass the evidence necessary to prove the facts of a case. So they are required by policy to collect any evidence necessary. Twice it says contracts, labor laws, relative things, collective agreements are part of it. The Act requires them to give you a chance to submit it onto the record, and they must take it into account. They must take your arguments about it. And yet this policy says complete fact-finding means all facts necessary are in this comprehensive list. And as you can see, the word contract is nowhere in there. No. So that's just one example. And they twisted everything in here. Exemptions, availability for work, suspension or dismissal. So they're creating a new process tree that overrides what is already established by law and by regulation internally, and then forcing them to follow it.
Well, so, and a couple of the bigger sort of principles that are there too, outside the finite of the EI employment situation, or the EI Employment Insurance Act, is that, you know, some things that I jot down is just that legislation itself, you can see, can undermine the Charter of Rights and Freedoms that gives people rights to their religious autonomy, the right to their body, you know, those sort of things. And then the other thing that it does is it seems to actually persecute a minority group, which is is also supposed to be illegal in Canada, right? Like if you did these things to a specific, maybe a visible minority group, say redheads or something, like, all redheads have to have this sort of thing done, or else it, would be seen as like a human rights infraction. And it's interesting that it doesn't. The last thing that I would say, and the third thing, my husband walked away from his job because of the mandates, was there is something simply amoral about the idea that an employer can tell you what you have to do to your body, and it's a permanent thing done.
Yeah.
Like, so should employers be able to ask women to be sterilized so that they don't have to have time off? Those sort of things. It's a big, I know this isn't part of your thing. I just wanted to add that in there for my piece, is like this, these legislations have undermined the greater fabrics that are supposed to protect the citizenry of Canada. And there is something really, I think, evil about the idea that an employer can demand what you do with your body and then fire you knowing that there's no social safety net that is going to protect you for not doing so. Again, it's that added pressure.
Yeah, and the worst thing is they allowed it to happen. I mean, we actually, that's a fundamental part of our argument. So I guess two quick responses. One is a decision was made in tandem with this BE memo that the EI tribunal was not a competent court of jurisdiction. That's what's part of the charter rights. So they were saying, we don't have any authority to deal with issues. You just can't bring them, we won't hear them. And again, that was a decision that was made just in time, just before the pandemic, that, we're not human rights experts. We don't know how to argue those things or decide them. And yet, we'll show that the misconduct test, or at least what they call the misconduct test, was specifically engineered to remove that factor. They are supposed to consider, and we can get into this in a little bit, the history of the EI Act, but they're required to consider whether your employer acts contrary to law. Lockouts are both federally and provincially prohibited. If you have a contract and they say, we're going to put something new in your contract, it doesn't matter what it's for, it could be for safety reasons. We're not going to pay you until you comply with this new term of employment. That's called the lockout. And prior to the pandemic, that was grounds for EI, right? If your employer wants to change your terms of employment, you either have to agree to it or the union has to ratify it. You can't just arbitrarily insert something new and say, we're not going to pay you, you can't come on the property until you comply.
Yeah, and this is such a complex issue. I mean, from the legality all the way down the line to, even to take a look at a person's self-interest and self-autonomy, right? What it means to be in charge of your own self. And you can say what you will about prostitution, but I think everybody, in one way or another, understands that when somebody's bodily autonomy is a part of the employment equation, it changes things. And that is what we've had here, our bodily autonomy, being in charge of our own selves and what goes in it, has been taken over by employers and then reinforced by government agencies, from the health agency to EI. And I think that's really scary because, and we're going to talk about this down the road, is precedence. If this precedence goes through, guess what happens the next time?
Oh, they're required by law to follow it.
Yeah, because that's what law is. Yep, that's what law is, right? It's a legal framework, and then what happens next is it's based on precedence. Whether the precedence is valid or not, once it's in there, then you can make another case on it. It's like building blocks. It's Jenga.
Yeah, one of the a 60-second summary of what happened in the pandemic, I think is really important to just boil down what happened. It wasn't just in EI, but it happened in EI. That for the first time in history, employers granted themselves the right to break the law by issuing a policy. Like that's never happened before, where they just wrote a policy saying, hey, I can do something, and they do it, and it's, hey, you broke the law. Yeah, but the policy says I have to do it. We'd be violating our policy if we didn't do it. And the government accepted that you can just grant yourself the right to break the law and break contracts just by signing a piece of paper saying we're doing it. And the government accepts it. Yeah, sorry, they'd be violating their policy if they didn't go along with it. Never mind what the law says. It's wild when you boil down what really happened.
Yeah, and employers actually have a duty to accommodate and a duty to the safety of their employees. And so we tried to hold my husband's employer to task with that. And what they said was they don't have to do any research on what the actual safety and health or the accommodation is for their employees. What they can merely do is do whatever AHS says, and that's right for they don't have to get their own researchers. Even if they're massive global companies, they don't have to put any effort in. They just have to do what AHS says is right for their employees, whether it is or whether it isn't. So it's made actually safety and accommodation for anything within with employers, it's a joke now, right? So now your health and safety at work is whatever the government says it is, whatever AHS says it is. Yeah.
And they're removing all of the ability to challenge it.
That's right. And you can see how the pieces, it's so complex, it's hard to tease out, and you can't really tease out. I don't think you're supposed to, because if one part of this fails, like let's say the employer wasn't able to force you into vaccination and you were able to walk away, well then the next piece to force you into doing what you're told is EI. And if that fails, then it's you need a QR code to work and you can't get a new job. And if that fails, you know what I mean? It's like they're interlocking pieces that it's probably the only thing the government of Canada does well is redundancy. If this program doesn't fuck you over, then this one will. If this one doesn't, we'll make sure this one doesn't. At the end, you know what you get? Nothing.
And it's always incompetence. We're sorry, we didn't mean to do it. It just, we'll do better next time.
It's hard to keep believing that. It's hard to keep believing that it's just incompetence and not malice, hey?
Yeah, well, anyone who has a process engineering background can see these sorts of things don't happen by accident. They're processes that are engineered. They're mapped out. They span multiple agencies and government departments. The idea that all happens by accident is really, like, statistically improbable to even begin to believe a claim like that.
So we kind of went through the EI, what the EI process used to be, what it is now. We went through one very distinct point of what it was and what the changes are. And then kind of we've been talking the last bit of what that means, both in principle and then in practicality, which means denials of claims without looking at the evidence. And it's really the employer that holds the key all the time, right? That code that goes on your separation papers means something, and then there's no longer the dependence on the human rights tribunal, which is now a joke, or the Charter of Rights and Freedoms that grants us the right to autonomy and our right to religion. So how, like, with the one example of that change that you saw that was made about facts, and facts are apparently now irrelevant, What? Give me a couple examples of what other changes are made, and then like how many secret changes were made in total? Do you know that? Like if just that one we discussed has such a huge downstream effect on people's
Yeah,
lives and their alienation, their ability to support themselves and their families, like just that one, think about just that one person that didn't get that. It's life ruining. And so then now your choice is your
yeah,
bodily autonomy or being able to support your family. What a shit choice to be in. There was more than one secret change made.
yeah. There was at least 6 interlocking pieces. I think one thing we should look at before looking at more of that is, what does the EI Act actually require? I think that's an
Okay.
important foundation, because if we don't understand what's supposed to be followed and what was done the decade before, then you don't have a
Okay.
baseline to sort of see how they've twisted it.
Okay. Let's do it.
Can you pull my slides back up?
Oh, darn. I'm terrible at doing the
Beautiful.
tech for
Nope,
you.
that's it. That's it right
Okay,
there.
great. Okay.
So I'll take about 3 or 4 minutes and just walk through the history of EI, and then we'll look at
Okay.
relevant sections of the EI Act.
Okay.
So just to set the stage, in 1998, there was a Supreme Court case called Rizzo. Um, a company had shut down and went into bankruptcy, and people applied for benefits and they were denied because bankruptcy wasn't in the list of acceptable reasons for losing your job. And the Supreme Court came back with a new framework for interpreting the law called Rizzo. And they said what you have to do is look at legislative intent. And what they did is went back in the Hansards, which is transcripts from Parliament, from the record, showing how the minister who brought in the act actually talked about, yes, this is a transition act, but it applies to all these extra situations and included things like bankruptcy. So the Supreme Court said from now on, when you're interpreting how to apply something like the EI Act, you can't just look at the words that are written. All legislation happens in, in a context. There's a situation happening, Parliament has to address it, they argue, they go back and forth in committees, and then they come up with a piece of legislation that's voted in. And you have to consider all of that.
Okay.
So just a brief history. In 1971, under Trudeau Sr., UI was socialized. So you could literally assault your boss, you still got EI. It was universal. There were some good things. They put in things like pregnancy leave. Of course,
Okay.
in the 80s, 70s and 80s, you have a destruction of our industry, right? With the free trade agreements and factories leaving. And in that time, our net debt to GDP more than doubled, and unemployment actually rose more than 50%. And it caused a huge problem. So they had a 2-year study. Both the House and the Senate in Canada produced 2,000-page volumes on what are we going to do with EI? Because at this point, 1 in 9 Canadians were on unemployment, and we have huge budget problems. So they made 2 changes. The first one is they stopped funding it. Prior to that, EI was split 3 ways. The employer, the employee, and the government actually took money from their budget every year and put it in. They pulled that out and said, we're not going to pay for EI anymore. We don't have the money. The other thing they did is they added this concept called just cause, which is a list of
Mm.
reasons that they pulled from labor arbitration and said, if you have one of these reasons for leaving your job, then it's justified, you get EI. That was in 1990. Fast forward 2 years, they've now lost $1.7 billion. EI was going to collapse because they had pulled that $1 billion a year of funding from the pot they were putting in, and unemployment is still going up. So they have to find a way to frame it. They dropped a bill called C-105 on Parliament the night before Christmas. They were supposed to vote on it when they came back from Christmas break. Obviously, you know what that means, right? And in
Right.
it, they made a change saying if you don't have just cause, you get 0 EI. So prior to that, if you didn't have just cause, you lost a few weeks, a penalty. So instead of getting 45 weeks, you might get 35, you might get 40. You just have a few weeks penalty based on your discretion. This said, no, you don't get any EI. We don't care how much you paid into it, nothing. And it caused an outrage. There were protests, there were riots, and again, all of this was mentioned in parliamentary record. 6 times in 2 months. So, for example, there were protests and sit-ins. There was a protest with 50,000 people in negative 25-degree weather all day in Montreal. There were arrests. There were threats on the lives of people in Parliament, or at least they claimed in the record that their lives were being threatened, their families were being threatened. So they actually had to plan construction projects across the country. And again, this is their own words. They were putting back doors in all of the EI adjudication offices because of the safety to people who you paid 2% of every dollar into EI your whole life. Then you're losing your job and it's not your fault. And you're being told, sorry, you're an EI cheater. You don't get EI. So they were forced to back down. 5 weeks later, they came out with Bill C-113, and we're going to look at that in a sec. And it had to make 2 changes to Bill C-105. Number one, they had to put 14 categories of just cause in the law. So it's not discretionary anymore. If you have one of these 14 categories of reasons for leaving, you automatically qualify for EI. No questions asked. And they had to put benefit of the doubt in, which is this idea that if it's not clear cut who is responsible for the separation, then you have to give them EI up front, and then you go through the process. And if it turns out they don't deserve it, you can try and claw it back. But to leave people with no income and no job for a year and a half or more while you're fighting this, when they're going to end up getting it later, was totally unjust.
Right. And it's that, do you feel like, we talked about that delay, deny, or deny, delay, defend, and you said and discretion was the last one you ended, is like this is that deny part, like who the F can wait a year with their bills to get something that they paid into? And the truth is too, when you're talking about this, so I'm a recovering social worker, and I think in terms of people, right? People, not really policies, process, and legislation. These people have thought they've paid into this insurance and that they're protected. So they're showing up there thinking they qualify because they've paid hundreds of thousands or tens of thousands of dollars into this program. And as Canadians, I think especially up until probably the 2010s, people believed in this. People believed in this sort of social safety net we have. So I just imagine in my mind's eye that because I want to give this a human face. A person has lost their job, a man, a wife, his 2 kids. He's walking into that AI office thinking he's protected, and so is his family, and he's being told no. And then when he appeals it and does a little bit of pushback, he's being told, well, you can push back and you can appeal, but sometimes between now and when you lose your house, we'll come up with a decision. And that's the human side of it. And I just wanted to add that in. I know this is really sort of dense legislative stuff, but I just want to come back to that idea of these are human beings at the end of this.
Yeah, thank you. I mean, that we're in that situation. My family member was let go in January of 22. We're now in February of 26. We still haven't had our court hearing yet. And he did lose his home to the bank, right? That's 30 years career gone, home gone. And now they're renting at exorbitant prices. And what does that do to the kids? What does that do to the marriage, the stress? That's why this has to be dealt with.
To their health, right? Like that stress over 4 years, and I am really feeling for you. What's your family member's first name? Let's give him a shout out.
Dale.
Dale, kudos to you, Dale. I mean, I'm sorry for what you've lost, but I know our audience will think this because we're really rugged individualists. I want to thank you. I want to thank you and Matt for bringing light to this. I'm sorry it's been painful for you. And I want to thank you for trying to take these motherfuckers to task.
Thank you. I appreciate it. Yeah. We're all in this together. We took a risk. we engineered our case to target the unlawfulness of the process, which is a huge ask because we're asking the court to actually look at what the government did and admit they engineered processes that forced decision makers to break the law. And we listed all the ways they did it. That's a huge ask. The alternative is they say that's all acceptable and has precedent going forward. So now the courts are in a very difficult decision, and they need to know that Canadians, this is not just about us. This is something that Canadians need to stand up and show them that we're in this together. We can't allow this sort of thing to happen again. I mean, this just cause is the entire basis of our case. In 5 years, just cause was mentioned 545 times across 4,700 pages. Think about that. That's a stack, like multiple encyclopedias of arguments just over how to deal with EI. That's how important the situation was. So we went back and read thousands of pages showing how 10 members of parliament, 5 ministers and deputy ministers, 3 directors of UI, and 2 parliamentary secretaries. That's just what we pulled. It's much more than that. They were clear that the basis to deny someone is just cause. If you have just cause, one of those 14 reasons, then you qualify for EI, end of story. And they were very clear that explicitly includes situations where the employer's alleged misconduct. Because it is common if an employer is breaking the law to just say, yeah, well, it's your fault, right? To get away from it. So this just cause analysis was required. So here's what the law says. Section 29, for the purposes of disentitlement, which is section 30 to 33, just cause for voluntarily leaving or taking leave from employment exists if the claimant had no reasonable alternative to leaving or taking leave, having regard to all of the circumstances including, and there's 14, the most important one is sub 11, practices of an employer that are contrary to law. There's also 7 and 9, which is significant modifications to your salary or to your work duties. That's changing the contract unilaterally. And 13 is undue pressure by an employer to leave employment. And this was upheld. Just an important side note, voluntarily leaving or taking leave, they're both there. There was many pages of debate on how to word that in the Hansards. And they came down for both because they said there's multiple ways to argue this, and if we don't have both, things will fall through the cracks. So, for instance, there's 2 ways to interpret it. Voluntarily leaving is I'm making a choice. I'm volitionally walking away. Taking leave is involuntary, something that's happening that's separating me, right? So whether it's intentional or forced, it counts. The other way to argue it is by length. Voluntarily leaving is a permanent separation. Taking leave is like a leave of absence, right? In this case, for safety reasons, you can't come on the premises until the situation changes. So no matter how you slice it, you have to consider all those factors. The DESTA Act is the Department of Employment and Skills Development Canada Act. I just want to pull out one section here. The powers of tribunal, section 64. The tribunal may decide any question of law or fact that is necessary for the disposition of any application made or appeal brought under this act. So they're clear that any question of law or fact that is necessary to decide the case can be approached. They're supposed to be looked at and argued.
Let's go back. Can you say what the tribunal itself is?
Yes. So I'll go to slide 11 again.
Okay.
There are
like what's its makeup? Is it like 5 lawyers sitting there? Is it a layman? Like who makes up the tribunal? Yeah.
They are appointed by the Governor General. It's a similar process to a court appointments, right? Judges. They are appointed to either 2 or 5 year assignment periods, depending on. It's arbitrary, right? The Prime Minister's office makes recommendations. The Governor General takes this list. She picks the ones who she wants. She puts them in there for a period of time that she decides. It's really important that they admit in their filings that 2/3 of these tribunal members do not have any legal training at all. They get comprehensive legal training when they start. So these are people who do not understand the legal foundation of how our country works. They're not lawyers, they're not experienced, and they're being given the task of interpreting very important, very complex laws that have a profound impact on our country. And the only thing they get is what they're given in training.
So
And
I want to put this in layman's terms for people. So they're appointed based on who likes you,
it
not
could be.
what your resume is, right? So it goes through a political channel of, could be nepotism, could be who likes you, could be you're just on that political side of who's voted in. But here's what it's not. It's not based on your resume. It's not based on that you have qualifications to do this job, that you understand this appointment.
Yeah, there's no requirement that someone's employment history is required. There's no justification to put it your way. You don't have to justify this person should be there.
Right.
The Prime Minister's office just gives a list of anyone he wants, and the Governor General can just pick from that list anyone she wants, and that's the way it is.
Right. Yeah. Governor General is actually the
Head of
leader
state.
Yeah. And then once we have, most people don't know this, they have for somebody that's not elected, they have a massive role in Canada. They actually are the head of state that then passes off that lead, but doesn't really necessarily have to after an election.
Yeah, I regret.
It's a whole other thing, but people don't know that the Governor General has a lot of power in Canada, is what I'm saying.
Power of the Crown.
Yes,
She
that's right.
supersedes the Prime Minister.
Yeah, that's right. That's right.
I do regret. I mean, I'm in my 40s now, but when I was back in high school, I had 1 credit of civics. It's less now. If you roll back the clock 100 years, civics was a very important part of life. You couldn't go to high school without passing a comprehensive civics and constitution test. If we don't know how our systems work, that's information asymmetry, right? That is a power imbalance because we don't know how this works. They do.
Yeah.
If we can't figure that out, how are we supposed to come up with a response? That's
Well, and I think that it's an important part too, like for their role, but that for such a large role, they are also not elected, right? They are appointed. They are appointed as well. And there's been some big catastrophes. For one, that crazy astronaut they put in there. And once they're Governor General, not only do they have that insane amount of power, I don't want to get sidetracked, but they are paid then for life. All travel, everything for life. So even that Governor General that got removed, she'll want for nothing ever. And this is who it is. It's usually a chick now too. Yeah. Anyway, carry on. Sorry, I didn't want to get sidetracked, but it's another prong to understanding this, because now we see a lineage of power of appointed, not elected people who have a lot of control over your life.
absolutely.
All right. I don't want to distract you. Let's carry on here.
Okay. So here's the last piece. So we looked at just cause, and we looked at the important reasons for it. We looked at the powers of tribunals, saying they must consider any question of law or fact that's needed to decide the case.
Yep.
So what does contrary to law mean, right? Because that just says contrary to law in the act. So over time, they've developed this.
Okay.
The term illegal has a broader meaning than merely contrary to the criminal law. It includes contraventions of employment standards, like the Canada Labour Code or provincial labour law, legislation, like provincial health and safety statutes, collective agreements, I've got the underlined, and licensing board certifications. So when they're doing contrary to law analysis, and this is binding, you can see the federal court decisions here, they have to look at the labor law, they have to look at the collective agreement. They can't just say, oh, she didn't commit a crime, therefore you don't get EI. So we actually went and looked at what happened. And from 2014, when the current tribunal was formed, this had multiple revisions. 2014 was when it was redesigned. From 2014 to 2019, which is 6 years prior to the pandemic, 539 cases were decided based on just cause analysis. So that's just to show,
Okay.
not only does the law say it, they knew what they were supposed to do, because that was what they did hundreds of times. There were many cases where contrary to law specifically was cited. There were 365 cases where contents of contracts were cited. So the tribunal member actually said, you violated section 2.4 of your collective agreement, you don't get EI. And they were supposed to actually do the analysis. I want to just highlight one, this is egregious. They were reverse engineering decisions. They were saying, we're not going to do contrary to law analysis, but we found they actually did for masks. So listen to this. Multiple people lost their jobs during the pandemic. This is 2021, 2024. And they complained, I wasn't safe at work. My employer didn't force my coworkers to wear masks. The tribunal member said, yep, that's contrary to law, even though it wasn't law, it was regulatory. And they said, you get EI. So they're perfectly willing to do contrary to law analysis when it suits them. But when it's going to collapse EI because 500,000 Canadians are going to be getting EI because their employers committed lockouts, all of a sudden, sorry, we can't look at that. And this is just a brief list.
And that's where you see, the authoritarian power is no longer just in law, right? You can see that we're seeing it with the CFIA in terms of their track and trace and kill programs, for the sort of food safety. We saw it with all the different provincial health agencies. I'm in Alberta, so AHS, that these absurd amount of power, again, these people aren't elected, and they really don't run on the research that they say that they do. They run on almost popularity.
And they don't have to prove it. Their opinion amounts to law.
Listen, they did so great. They did so great about these COVID shots that they had to lock up and seal the outcomes of them for 15 years. Yeah. You know what I mean? So it's very interesting. I really like how you're bringing out the interlockedness of it all. So if I could just recap that bit, you've got 539 cases went through for just cause from 2014 to 2019. So to put that into some sort of context, here, the population of Canada, for those who don't know, in 2022 was 38.9 million. So it would have been a little less earlier than that. So you can see it actually was not a huge number. What you were trying to show there too is that they are willing to do this. But what I'd also like to shine a light on is that, okay, so in 2014, the population of Canada was 35.5 million. And so there was 539 just cause cases that went to tribunal just for the just causes in 2014 to 2019, because I suspect coming up here, we're going to show that there's a lot more that were rejected too. So I want to look at the willingness to take a look at this pre-COVID, which they clearly were, but also how that's not a lot of cases for the population of the country pre-COVID, and it's about to balloon, I suspect.
Yes, we cover the stats in depth. Part of the problem is the complexity, and Parliament acknowledged this in their reports. Learning how the tribunal works and representing yourself is a very intimidating thing, right? To try and challenge the government, you're making a decision wrong. Mm-hmm. So the statistics show only about 2%, only 1 in 50 EI applicants who is denied by the EI Commission actually takes the very difficult step of either paying someone to represent them or learning the process and challenging what the government did. So it just has a background. In 2019, that's before the pandemic, right? So that should be a good baseline. There were 988 cases at the tribunal. There were over 1 million denials, but only 1,000 of them went to the tribunal. So
well, I suspect that's multifactorial, like people are intimidated, right? But who the hell can, like if you're lost your job and you're trying to get EI and you can't get, who the hell can afford a lawyer?
Yeah, and who has the time when you're trying to find a job and you're trying to do something to provide for your wife and kids or your family? Like, what do you do?
Dang, that's a small number, hey? 1 in 50 proceed, like...
Yeah.
Yeah, okay.
That just shows, and Parliament acknowledged that, saying it's a very brave person to actually take this all the way to the Federal Court of Appeal. So I sent that to my family member to encourage them that, hey, you've got multiple senators recognizing that very few Canadians would actually do that.
Well, and I want to recognize that here too, as somebody that likes to take on these things, and I'm in my own thing, is like, not only is it brave to stand there, because as Canadians we're taught to be nice, and by being nice we mean do as you're told. So that's one, going against sort of the culture of it, but two, the time and mental exhaustion it takes to do this, to even just get there and then actually stand in the face of dissent and be a dissenting voice is so difficult, because, you know, like you said too, this was 2022. It's 2026. You and Dale have been going through this for 4 years. So, you know, by the time you get to the tribunal, they're making sure you're exhausted. So Dale, we're supporting you. You've got people here that are supporting you. Keep going.
Thank you. Just the best way people can help, we'll come back to this later, but we have public interest letters. We're asking the courts to do something very difficult, which is to acknowledge what the government did. So we have pre-written letters. We've had very good success with these. They're pre-written. You can either print them out as is, or you can add your own wording to it. And the only thing we ask is that people print out multiple copies of these letters, and they get sent to the relevant decision makers. So they're going to the courts, they're going to the Attorney General, they're going to the leadership at Employment Canada, just explaining, like, we're Canadian citizens, we rely on the EI program, and we really would appreciate that the law be upheld. And there's an appendix form that if you had your own EI decision, you can fill it in with the details of your case, and you can add your story to our case, which I think is really important, because it lets everyone know this is not something that's being done in secret. There are thousands or more Canadians who are involved. And we've created a way that everyone, like 500,000 people, were denied EI on this basis. We want to get as many of them to put their story into our record too. To let the judges know this is not just one person.
Well, and it's the human part of it. It's easy to say, oh, this guy didn't make it, or 1 in 50. And again, I just want to bring you back to the pain that it must be to walk in there thinking, and I'm familiar with it, thinking you're going to be saved by Canada's social safety net. Or even if you don't think of it that way, you think of it like, I paid into this in order to be supported through the hard times, and then you realize it's been a sham. It's very difficult. And I think there is something to a feeling of betrayal or losing your religion that's happening now in Canada, that the idea that being Canadian meant healthcare, and we support the poor, and we make sure we're taken care of, and we have these public programs that are great and world renowned. When it collapses, it's almost like the feeling of losing a deity, right? Losing part of that self that you thought was yourself. And there does seem to be some sort of grieving. You either grieve it and realize everything you were told is a lie, or you bury your head in the sand and you think Canada is great.
Yeah,
and you just keep going.
We're taking the first one. I mean, I didn't realize the time commitment when I said yes, but when I researched how and why they did this, that's when I realized we can't stop. We cannot let them set a precedent that they can just self-declare emergency. And by using the word emergency, they can just start violating all the laws using sort of internal discretionary processes.
So and thinking about that, let's try and put a human face. I want people to think about their family and friends that have kind of gone through some of this as we go through this summary of the impacts, right? Because these are numbers, but these aren't numbers. These are people, and for each person, there's probably kids, wives, husbands, grandparents that are depending on these people, and so we got to think of them not only as a number, but a number connected to a community and of dependence.
Many thousands of these people lost their home in a pandemic. They lost
Yes.
their job. Think about divorces. What happens when one partner loses their job, the other one gets upset and said, "You should have taken this shot. Now we've lost our home." What does that do to the kids?
Can I tell you, can I just humanize that even more if you don't mind?
Sure.
My husband, I love the shit out of that guy, just in case anybody doesn't know, but he works in an industry where they have a certain term called the golden handcuffs, where you make such good money, then your whole life and family is bound to it. And there was a lot of, I don't give a shit what you want from the spouse. My house in Kelowna costs $800,000 and I plan on staying here. I don't care what you think. You're taking our kids to hockey, and that's a demand. I don't give a. So there's a lot of probably women too, but men who had to sacrifice their body forcibly from, just even within their family. And I can't imagine what that does, but I know that it's left them with this, men and women with a sense of betrayal.
Absolutely. We've had family members who had untimely funerals. We can tell it was because of the shot, and we were not permitted to attend their funeral because we were unsafe.
Yeah.
Like, we can't attend our own family's funeral.
Yeah. Yeah.
And then now you've got MAID. People don't have their home. They're getting pipelined into this. Yeah, we'll just kill you.
Do you want to hear a crazy MAID program, and then we'll get back to stats? So my friend's grandpa, who's a vet, he's a vet in the war. At the beginning of COVID, he's like, he lived in an old folks home. He's like, just come by. And then slowly they worked on him. It's like, you can't come by. You can't have visitors. You've got to get vaccinated. And he tried to hold off. And from a guy who had a robust, he's in his 80s, a robust social life. He was here and there. He's a brave guy from war. He then went to a vaccinated guy, scared to leave the home, wouldn't see his people. So then he got vaccinated. So then he got turbo cancer and he was dying. So he chose the MAID program, right? And they wouldn't let his grandson go there while they were killing him because he was unvaccinated. Yeah, and it was just, we're sneaky, so I won't tell you how it ends, but Grandpa didn't die alone, but it was, something. So here it is, a man you're going to kill. He's clearly not going to get the virus from somebody who's unvaccinated. It's just, it's another example of how things are so bizarre. And again, I wanted to humanize, too, how much control that that not just the legal system has, but the medical system has on our lives. So let's do this. Yeah.
That's why we have to stand up.
Yes,
we
right.
cannot let them keep doing this to our country. They are our public servants. We hire them. We pay for them under our constitutional framework.
And what David and I say is it's time to build your own life raft. Thinking that the government is going to come solve your problems and take care of your health for you and make you well and make you safe is done. You have to do it yourself, So I think thinking about how we can do it ourselves while we go through this because they're not coming to help you. There's no program that's going to help you. I forget who it was that said the worst words you can ever hear is "I'm from the government and I'm here to help." Yeah.
That was Reagan.
Okay.
He might not
Was
have
it? Oh,
originated it, but
thanks.
Reagan said that quite a few times.
Yeah. Thanks for.
So
I'm
EI
terrible.
stats.
No, who did what? Yeah. So let's go through these. I'm going to step up for 1 second while I go through the stats.
Okay. I don't want to get into too many details because sometimes eyes glaze over. But I just want to highlight that as a baseline before the pandemic, there were close to 1,000 cases at the tribunal for EI. Then we had lockdowns, where we shut down most of the world. Never in human history have we quarantined healthy people to stop a pandemic. Nonetheless, when that happened, you can see that cases dropped to 650 cases per year. So that's a significant drop from close to 1,000 to 650 cases. Then mandates come in at the end of 2021. You can see an explosion in EI cases. There's now 1,400 cases on average per year. So that is more than doubling from the lull when we had lockdowns to the mandate. So it's more than a doubling of EI cases at the tribunal. Just a side note on fringe minority with unacceptable views. In 2023, 41.5% of all tribunal cases for EI were quote unquote mandate misconduct cases for non-compliance. That's more than 2/5 of all cases. So to anyone who says we're a fringe minority, we are not. This is almost half of all EI cases were people who were told, sorry, you're insubordinate, you're not getting EI, and no, we're not going to follow the process. I'll just call out one other stat while we're waiting. This table is a breakdown of rates of being accepted or denied EI. And this is from 2021 to 24, so this is during the pandemic. Oh. So I don't have the chart up, but I will say this, that the people who were told no because of mandate misconduct was more than 4 times higher. Roughly 1 in 5 people who go through the process at the tribunal are given EI at the end of it because the tribunal member says you've proven your case. When you look at people who are there because of non-compliance with the mandates, all of a sudden it's 6%. So that's more than 4 times what happened inside the processes, which we're going to walk through, that caused a specific group of Canadians to be told no more than 4 times as often.
Sorry,
I can't
guys.
hear you. Beautiful.
Yeah. Gotcha. Sorry. So
That's
those
okay.
stats are actually staggering that you put out there. It's amazing. It's amazing to me how much money must be taken in by that program. It's also amazing to me. Well, so I did a little look at, if we're on the stats here, I did a little look at the government payout too, just because I wanted to know, what they take in and what they put out, and they may not understand the program, but having been a social worker before, I'm just going to share my screen for a second too.
Yep.
Is that the bureaucracy of running, because everything government is everything in government is poorly managed, right? The bureaucracy manage. When you look at it, the bureaucracy, so the amount of people that they have to employ now in order to get the bureaucracy, because now it's a lot of that, what you're saying around the stats. It's like they take the person in. There's never anybody that's just like, yep, you're okay, unless it's like a maternity leave. It usually is a lot of paperwork. You have to submit it. They lose it. You resubmit it. You resubmit it. There's a there's this, there's that. The expenditure around it far exceeds what actually makes it back to the people, and you can see that here. And I know that you said that this is probably because AI doesn't understand actually how the program is run, but you can also clearly see that it wouldn't really matter. The bureaucracy of the system is eating up a good portion of the money that's taken in that should be going back to the people.
Yeah.
So say for a fiscal year, it's interesting to me.
While you're there, I just want to highlight.
Sure.
I was just going to say that number there was pulled from the report. You can see regular benefits is 12 billion.
Yeah.
In total, there was about 25 billion. The 400,000 to 500,000 people that were denied EI because of misconduct is 12 to 13 billion. You're talking about a 50% drawdown. That's why they had to engineer these processes, because if they would have had to pay out that $13 billion to 450,000 Canadians in a short 2 or 3 month period when the mandates were in place, what are you going to do? Like, it's going to collapse the program, right?
Well, and one could say, really honestly, Matt, the things that they did actually did collapse the whole economy of Canada. It's being held up by toothpicks and fairies now, right? And the only thing that's keeping it going is that we continue to believe in it, right? So that also tells you, and the same with CPP. CPP is a total joke. Anybody that my age thinks they're still getting it also believes in fairies. But, I think that's a lot of these programs now, like our healthcare. No, I mean, I'm not sure of anybody that still believes in that. In fact, we're getting sicker every day as a population with less access to the health benefits. And so that makes me think that it's not just been since COVID that these programs have been mismanaged and misused for decades.
Yeah. We're just looking at EI, but I've been connected with people who have been looking at WSIB for the last 2.5 decades, and they've got about 40 billion. And I've heard people looking into the same thing with CPP. Again, I haven't investigated that one myself.
I have.
If we can prove it's happening in EI, you can prove it's happening in CPP, WSIB. The question is, where is it not happening?
Well, so about just over a decade ago, when I first started running a group for chronic illness, people like myself, and at that time I wasn't able to walk very well or anything, I decided to try and tap my CPP disability. So one thing, you can get CPP disability, or you can get your pension early. I'm way older than you, so blah blah blah. And I looked back, and they actually audited CPP, and one of the things that they found was that same thing that you found, which is they deny all applications at the beginning. And then the people actually that are willing to go through the appeal, about 40% made it through, and that they were using the process to weed out applicants that actually should have got it. The other thing that they found during this audit was that 65% of information given out by CPP representatives was wrong. That the people administering the program actually didn't understand the program. And I think you can see that in all programs now, is that incompetence. And this was years ago, right? It ain't getting any better.
Yeah, we've proven that happened in EI extensively, time after time. Do you want to look at a couple other pieces of process engineering then, or?
Yes, I really do. Yeah, I really do. Thanks for that. Thanks for being patient while I tried to figure out my camera.
Oh, no problem. This whole new world was new to me too. I'm an extreme introvert. If you had told me in 2019 I would be doing podcasts, I would have laughed. No way. But here we are.
Well,
All right.
yeah, but it's a great way to get things across. And again, I just want to say for people that I'm adding links down at the bottom on the banner that you can click on to get more information. And then I just hope that people will share and repost this video to get the word out so we can support these guys.
Thank you. Appreciate that. Can you pull my slides up?
There you go.
Okay. I'm not going to walk through all of them. I'm just going to highlight a few of them. If people want, we have a presentation. I'll put the link in the chat in a minute.
Okay.
Actually, you know what? I'll do it now.
Well, yeah, and then I get it up there. So again, there's a whole website of all these links I'm putting up. They're done by Matt. It's got a lot of information. It's really dense. There is one spot where you can look down on these. You can get these quick 2 to 5 minute videos that give a quick hit breakdown. Then you can delve deeper by checking out these specific links we're putting up. But again, it is all on Matt and Dale's website here. And there's a lot of information here.
Yeah. So I put 2 links in the private chat. It's presentation and slides. That's probably the best way to get the big picture. It's 1 hour and 40 minutes. And it walks through the entire presentation of the entire case from beginning to end with details. So slides, that link is what we're looking at right here. And the other link is the presentation. And below the presentation, we have timestamps where every single section of the video has the actual documents and evidence under the timestamp chapters. So you can pause at any time and you can go down and see the source documents that we're relying on.
Okay.
So I just want to show a few of these steps, how a few of these steps were engineered. We didn't really talk about falsified ROEs, but just to reiterate, it is a criminal offense to knowingly put false information, and it is the only sworn evidence.
And a reminder, an ROE is a record of employment. That is what you get when your employment is severed, and it's not filled out in any part by you. It's all the employer.
Yeah.
All right. Sorry.
Thank you for that. We've already talked about the BE memo a little bit. I want to talk about changing facts briefly. This can be a sanctionable offense. So if you're before a court and you're arguing something is true all the way through, and then at the midpoint you turn around and start arguing, actually no, it's false, and you start arguing the opposite, that's called changing facts, right? And you can actually lose your license to practice law if you're changing facts. So I want to show, at the EI Commission, we presented 18 statements from 4 sources saying that we were on an approved leave of absence. We should have had ON on a record of employment. They processed that by saying that we were on approved leave of absence without just cause. Now, of course, if they did the just cause test, they would have had to look at the contrary to law analysis we've already walked through. We would have got EI. So when we appealed, they sent this in. The attention of the tribunal is drawn to the fact that a clerical error was made in the notice sent to the claimant. The notice indicated the claimant was on a leave of absence, whereas it should have stated he was suspended due to misconduct. This is the first time the word suspended appears anywhere in the record. And to double down, they cited a case de Rossier, saying errors which do not cause prejudice are not fatal to the decision. So just think about this. The entire case was being argued as leave of absence. They said without just cause. They didn't do the just cause test. Had they done it, we would have got EI. So they tell the tribunal, and this is an unsworn statement, they're not held to perjury here. Oh, it's just a clerical error. You know, we said it was leave of absence. We really meant to say suspended. Yes, it's a different part of the act. Yes, it's a different analysis, but a clerical error is if you misspell someone's name, right? Or you put 1-7.
That's what I was going to say. Yeah, that's what I was going to say. That's a clerical error. That's a misspelling or a misdate or, spell
Yeah,
check, put something else different. But
this is
this
changing the
is,
test
yeah,
and
it's
changing the
changing the
test.
tune. It's changing
Absolutely.
the whole thing, right?
But
So,
that's
do you suspect that this happened because when you look at the original as claimant is on a leave of absence, and it was unjust cause, right? And that metric wasn't applied. Is that when they looked at the process that was coming up? That I mean, this is just a feeling thing. I know it's not a fact. Is that they thought they might lose under that, and so they
abs-
changed the game.
they had to because their final answer was your leave of absence without just cause. They didn't do the just cause test, right? We've
Right.
already looked at just cause. You must look at whether they acted contrary to law. We proved they were acting contrary to law. So they had to find a way to get out of this leave of absence without just cause branch, which is Section 30 in the Act. So they actually said, oh, just pretend it says suspended for misconduct, which is a different section in the EI Act with different tests, different legal analysis. It's egregious, and this is not a sworn statement. So they can just say, pretend we did something totally different, different tests, different definitions, and it's not fatal, so don't worry about it.
And can
Like,
I
people,
ask you, so when somebody is suspended at work, there's a whole process by the employer and a set of paperwork that says they did this and they did, like,
yeah,
there's policies around that to suspend somebody. You can't just be like, hey, you're gone. Everything's a bureaucracy now. They probably had 3 strikes of something before they were put off work. And paperwork would be in Dale's file, is there?
yeah, there's supposed to be. There wasn't. They never used suspension. That's important because most collective
It
agreements say if you're
is.
suspending someone, you have to pay them until you've proven misconduct. So if someone is accused, for instance, police who are accused of corruption, right? You have to put them on paid leave until you can actually prove they were doing something corrupt. Then you can strip their pay from them. But there's, like you said, not only is it paid the whole time, but there's a full investigation with grievances and arbitration that has to take place. None of that happened here. We were
So
all
it's
on
clear
accrued leave.
he actually wasn't suspended. It's clear through the paperwork on the employer's side that it was not
Yeah.
a suspension.
We
Okay.
had
Yeah.
18 statements from 4 sources in the record.
Wow.
So I
Wow.
just wanted to hide, this is just one thing. This is sanctionable if you're a lawyer. And yet the EI Commission, we've proven this happened in many cases where they changed the facts to avoid. I want to just talk about templates briefly. This is a really egregious one. Uh, so between 2013 and 2015, they underwent a large overhaul of the tribunal system. They hired KPMG, one of the famous Big Four companies, to come in and do an analysis of how do we make this process better for Canadians. So I want to just highlight something from an annual report. Between fiscal year 16 and 17, the tribunal launched 5 new releases of its case management system, called Atrium. Capacity was enhanced with new features like assignment tools, right? So you can bounce cases back and forth and automate the process of getting decisions out. Efficiency was further improved by developing decision templates pre-populated with legislative text related to issues at hand. So they're saying in order to make the process more efficient, to have more cases per week or whatever, we're going to have templates that are pre-written. They're chunks of paragraphs that already have case note citations and footnotes built into it, right? So when you insert a template
What?
that has a case attached to it, you are already predetermining the outcome to the case. It gets far worse. It's far worse than it
Holy
sounds.
cow.
Yeah.
Yeah.
So here's the style guide. This is like their Bible, for lack of a better term. When they're hired on day one, they're given this guiding that governs how they do their cases. So I just pulled a couple statements out. From section 1, a solid structure will serve as the backbone for your decision. Recent templates in Atrium give you solid examples. So they're saying these pre-written blocks of words are the backbone for your decision. Get this.
Well,
This is from Format. Decision templates help with readability. There's your pretext. Make sure you use the most recent decision templates. There's a command. They are required to use the most recent decision templates. Why? Because these templates have benefits. They often set out the legal tests in advance. So after they put this template, go ahead.
And it further intimidates the person looking at it, right? Because then you look at it and you say, well, all this must be legally true. I clearly didn't qualify because, you know, they've got all this legality here. And,
that's exactly,
you know,
it.
I totally can't fight this because, you know, all of us are idiots when it comes to the law. The law is, one, dead. The rule of law is dead. But the other thing is it's written in a different language that we don't understand, and it's become so perverted we don't even know the process. So, you know, so let's go back to the guy with the family. He walks in there, he realizes the social safety net isn't there. He's like Dale, he gets set balls. He's like, I'm gonna do this, where's my people? I'm gonna go here. And then he gets a decision template that looks like this, full of legal jargon that already lays out why he can't get benefits.
Yep.
And it's even more scary. It's very hard to advocate for yourself. You likely don't understand it, and you really don't understand what it means.
Yeah, and they don't. I don't know if they expected people to start reading through all their annual reports and third-party audits. I did. So they had an evaluation in 2021 of this whole template thing. So the report says they were given plain language training in January of 2018. Then they were given 15 months to practice using this whole template system before they began to study their decisions for analysis. And the sample size was the whole tribunal. They didn't pick one or two. They picked all 50 tribunal members and sampled their cases.
Mm-hmm.
So here's a statement. Some tribunal members expressed challenges applying training recommendations, particularly those delivered by non-legal professionals, or inconsistent with templates for internal messaging. So they're being given these templates, they're being given training, and we've already looked at what happens when you have an internal messaging, the BE memo, that's different from what the law says. 48%, 24 of 50 tribunal members, when they asked what additional training or support would you like, the number one request from tribunal members is we need help with these decision templates. Why? Well, because they're inconsistent with templates or inconsistent with internal messaging. We don't know what to do. So even
or
the tribunal members.
Would you say this is a possibility? Inconsistent with morality. That maybe some of these tribunal members don't think that this is right or don't agree with how it is, or that they feel like they're there to actually do a job and write their own decisions.
Yeah. Well, I'll show some examples and I'll let people come to their own conclusions. But I think you've laid a very important question on the table. I wanted to set this in context so that people understand this is the background to consider the rest of what we're going to look at here. I'm just going to look at three of them.
Can I say one more thing before we go on?
Yeah.
This is that also means, if that's possible, that these tribunal members are morally conflicted by these templates. That means this is a great place to intervene, because they can probably still hear a human voice. And, you know, we're going to go back to your public interest campaign. I want to put a plug in it here, and we'll go to it at the end, is that if people are conflicted, we can pull out that human side in this place with these tribunal members, because that tells me a lot of these people don't want to do what they're being told. Well, I just wanted to put that plug in there, because here is a ray of sunshine. Here could be a ray of sunshine.
Thank you. That's important. But we proved using their reports that they lost 28% of their tribunal members in 5 months.
Whoa. Yeah.
And many of them still had time left on their appointment. So whether they lost their job because they wouldn't comply with the mandates themselves, or whether they were conflicted with what was happening, we can't prove that. But to lose almost a third of your personnel in less than half a year. And then because of the explosion of cases, they had to increase by 50%. They doubled the remaining tribunal members in about 6 months because they were slammed with such a backlog of these cases.
And because it's by appointment too, you can figure now they've stacked that deck. Like you can see that with the RCMP and also AHS. It's now doctors who will comply. It's now RCMP that will comply, because anybody that was going to work under moral or a principled standing was either castrated and still, like, morally castrated and still there, or they left.
Yeah.
All right, I'm interested in these historical cases.
Yeah, so I think we'll just look at three. I'll highlight three. There's a lot more, but these are the most egregious ones.
Okay.
So we all know what cherry picking is, right? You pull something out of context and you try and represent it as something else.
Right.
So there were 5 cases that were cited 2,500 times. And again, keep in mind templates. There were templates written that cited each of these cases, and you can see Bellavance was cited 300 times. Misconduct was cited 850 times. In each of these cases, these people were denied EI because they admitted they broke their contract. For instance, Lemire was selling contraband cigarettes at work. It's a criminal code offense. He admitted to it and said, yeah, my boss asked me for them, I got him for him, he was on work, he was denied EI. McNamara and Parody failed drug tests. They worked in the oil rigs. So they were either high at the time or recently high. Nothing you can do, right? So in each of these cases, the judge said something like this: the employer's conduct is not a relevant consideration, which in those situations, under those facts, that's true. You knew what your contract said, you broke it intentionally, I'm sorry, you don't get EI. They pulled that paragraph out of its context and used it. Now, any time that someone alleges misconduct, they're using that statement that we're not going to consider what your employer did. Wait a second. The law says you have to look at whether they acted contrary to law. They found 5 cases out of 500 where the judges said we're not going to investigate what your employer did in those cases because they broke their contract, and said, oh, see, the judge says we can't look at what your employer did. That's binding precedent that we now cannot look at what your employer did at all. And these were shoved into templates that were cited 2,500 times.
Okay, so let's stop here and let's give a definition of 2 things. Your definition. What does cited mean in the larger context downstream? And what's precedent mean in the larger context downstream? So that people can understand when you're reading these 3 or these 5 cases, it seems like a one-off, but there is a lot greater context. So let's give a definition of cited and precedent, and then what it means once these are laid down, particularly if they're laid down as a template versus a robust decision. Yeah. Okay.
So the way that our common law system works, we inherit it from Britain, which goes all the way back to the Magna Carta, that the decision makers, we'll call them judges, they have different titles, we'll call them judges, they're supposed to consider all of the law and the facts relevant to a case, and they're supposed to make a decision based on what's happening before them. That's called a precedent, where they'll look at a series of facts and questions and come to what they believe is a fair decision, and that becomes precedent. So the next time you go before a judge with a similar set of facts and legal considerations, you don't have to do the whole thing from scratch again. The judge can look back and say, yep, the last time someone was accused of assault in these situations under these conditions, this is how we had to determine the case. So it's a way of referring back to history to have consistent decisions, which, if the cases you're citing as precedent are done correctly, it's beneficial, right, to not have to go through this cycle over and over and over again. The problem is when you have a case that is decided in error, and then you now turn that into a precedent, that must be followed in the future, as a shortcut, we're not going to examine the facts and arguments in your specific case because we already have cases about misconduct, and we're not going to. Here's an example. Put it this way. If I was accused of assault and I was standing in front of a judge and I said, Your Honor, I'm guilty. That's called a guilty plea. There is no trial, right? Because you have made a confession of guilt. You work back and forth with the prosecutor to determine how long your probation is or whatever, but you admit guilt. If you say, Your Honor, I'm not guilty, the next thing you have to do is schedule a trial, right? You have to have evidence, you have to have witnesses, you have to cross-examine, you have to see whether or not you're actually guilty of what you did. Here's what happened in this situation. They found 5 cases out of 500 where the judge says we're not going to investigate what your employer did because of proven misconduct. They pulled that sentence saying not investigate the employer out and said that is now precedent. We can never investigate what your employer did anytime misconduct is claimed. Not. So here's the analogy. I'm accused of assault. I didn't do it. I stand before the judge and say, Your Honor, I'm not guilty. I didn't do this. Now imagine a prosecutor looks at the judge and says, Your Honor, look, I found 5 cases in the last 2 decades where we didn't have trials for people accused of assault, so we can't have a trial here either. You just have to take the allegation of assault on its face, and we can't hold a trial because here I found these cases where we didn't have trials before, so you can't investigate the situation here either. That's what happened. How is that fair? Now this is also sanctionable. I want to do one other definition here called abuse of process. It's under the principle of procedural fairness in law.
Okay.
Abuse of process is to misuse or pervert regular court processes in a way that is not justified by the underlying facts to gain an unfair advantage in a proceeding. Right? The Supreme Court put it this way. If claimants have a legitimate expectation that certain procedures will be followed, these procedures will be required by the duty of fairness, right? So the EI Act says you must investigate whether the employer acted contrary to law. That's part of your test. Now you've got EI Commission members who come along and say, yeah, we're not allowed to do that because we have these precedent from previous cases where the judge says we're not allowed to investigate whether the employer acted contrary to law. So you just have to take that allegation as true. You can't investigate it, right? They have just changed regular court processes in a way that's not justified by the facts. The facts say you're accused of misconduct for not complying with a policy. And they think, we're not actually going to, we're not going to actually investigate that. So it's not only a huge fairness problem, it is abuse of process, and that can be sanctionable, right? If you're a lawyer and you find a way to twist the court process to say, we're not going to hold a trial for this assault case because 5 other people in the last 20 years didn't have trials when they were accused of assault because they pled guilty. So just take their guilty pleas in those cases, apply them here, on we go.
Yeah, and this idea of precedence can, on one hand, it could be, they say it's about fairness, but if you know about Thomas Yaves, he's a fella in Canada. I'm going to share my thing, and we're going to go over the criminal court to give a great definition of why these precedents is, and actually not about fairness, but possibly an insidious rot. This fella in 1983, I followed his case through the Innocence Project.
Yep.
This fella, can you see it? There we go.
Yep.
Oh, is it not going to show it to you? Of course.
You can put it in archive.is. If you copy it into archive.is, it'll actually bypass the paywall.
I don't know how to do that. I'm going to just do this one. So anyway, this fella in 1983 was found guilty of killing his 2 sons by fire. Arson investigator, just so you guys know, those arson investigations are usually bullshit. The people that are the great investigators have taken exactly maybe a weekend course on it. So let's look at this here. So he went through, so 37 years later, it was found that the testimony that was given within his court case was bunk, that this arson investigator actually was so far out to lunch in his assessment of how this fire was started, and that in actual fact this guy was probably telling the truth, that these two young boys, his adopted sons, had likely, I don't know why this won't do this, had likely started the fire themselves. Now here's the clincher. This case over those 37 years was cited 201 times as precedents to convict 201 other people.
Wow. So decades in prison for this man, but then how many more decades for the other hundreds of people?
Yeah, so then on top of those 201 that were convicted, then their court cases were cited. So it's one of the most cited court cases in Canada as case law, and 37 years later, it was decided as bullshit. It was all junk science. Yeah. So you know, again, I don't want to give a tangent, but look up that guy, Thomas Yaves. When you think about, well, I mean, it destroyed his life, but look at how many other lives it also destroyed. So when we're talking about this through the EI channel, like you said, you get those 5 ones there, and then there are 5 cases there. It's cited. Then those side, you remember that old hair commercial, and so on. She had beautiful hair, and so on, and so on, and so on. It's like that, and we have a lot of junk science when it comes to our court systems. And I mean, of course, you've seen that during the vaccine mandates and the mask. And I like how you mentioned before, is never before was it ever thought of to sequester and quarantine healthy people. And in fact, right at that moment in time, none of the pandemic from the provincial all the way up to the WHO suggested that masks or quarantining the healthy was a good idea. It was never part of the problem. So you talk about junk science and precedents, right? So I think this time it has been one of the biggest ideas of we need to rethink the precedent model. And I'm so glad you're bringing it up here, because here is another example of how not only does it work in the one case, it leads to errors systematically like a rotten web.
And we've proven it. We proved the 5 cases they have used. We proved the 2,500 times it was used to deny people EI. We've got everything linked. So we're not just suggesting a theory, we're actually showing concretely exactly which cases they abused and how many times they abused them.
And do you think they know that? Do you think that they set up, so, you know, we talked about like this, I mean, there just can only be so many shitty, malevolent redundancies before you're like, this isn't an accident. It does seem like having these templates out there that then they could cite and build upon is likely not accidental, and in fact it seems to have fiscal returns from them that build exponentially as they're used.
Yeah, that's one of the things we're trying to get answers to, that we're hoping the court can order, because we need to know who created these templates. We have proven that these templates were cited 2,500 times. We've proven the cases they cited. We don't know who wrote the templates, and we don't know how did those templates get inserted into the case. Is it a machine learning that does it automatically? Are they picking from a list and hitting a button? Is there some sort of keyword matching where it suggests? Right? We have no idea how this template system works, and we don't know who writes the original templates. So it is quite possible that because these templates were cited 2,500 times, that maybe in 2,000 of them, the person writing the template or the person inserting the template didn't understand the implications of what they were doing. They were just taught in misconduct, these are the cases that apply. The employer's conduct is not a relevant consideration to examine, hit the button, and there you go. Maybe they didn't think it through. We argued it was ignored. We have argued this unfairness every step of the way, and they have refused to touch it. They haven't approved or denied it. They've just not put it in their decision so that you can't appeal it.
Yeah,
and
and it
we're
can
continuing
definitely
to say,
lead to confirmation bias, and you could clearly see, like, I'm sure you've been an overworked employee before, and
Mhm.
I mean, everybody has where you can see that it's like, oh shit, I'm under the gun. I'm just gonna. This kind of looks like this. I don't want to go any further. I'm just gonna put this template in. Could be one reason, or another reason is people are. We have such a culture of fear now
yep,
that's been cultivated, and people don't really want to step outside the norm. Think how many times you hear somebody say, oh, you can't say that, or you can't do this, or you can't do that. Well, it's even more of a pressure cooker when you're inside, a public, a public industry, right?
yep.
All right. So then, once we go by this precedent, what's the outcome of these cases? So you cited the five. You say how they were wrong. We talked about
Yep.
the templates. So where do we go from there? Because that's, for me, that's alarming information. This is supposed to be a human services industry that clearly doesn't serve humans. It's clearly a
Yep.
fiscal industry that's run politically. So now where do we go?
So that's the next slide. We can pull the slides
Oh,
back up.
gosh, that's me again. I shouldn't be allowed to be in charge of these. Sorry about that,
Mhm.
Matt.
No problem. So we're showing now how this actually applies. So we showed one
Okay.
example in parity where the judge said the employer's conduct is not a relevant consideration. Why? Because
Okay.
they broke their contract. So over the years, there was this concept called a misconduct test developed. Now, to be clear, there is no test known as a misconduct test. What you have are judges over time saying you have to meet all these different elements. So before the pandemic, there was four. There had to be something willful. You had to violate a policy. The policy had to be clear, and you had to know the consequences. And all four of those had to be met. And if they weren't met, then you weren't guilty of misconduct, right? So if the policy wasn't clear, or you didn't know you'd lose your job, then it's not misconduct. If it wasn't a willful violation of the conduct, it wasn't possible to be misconduct. So they changed this test. They took this employer's conduct as not a relevant consideration, and they shoved it into the test. I'll show you how they did it. Here's how the process works. An employer terminates a worker alleging misconduct, right? So then in misconduct cases, you apply this four-part test. Was it willful? Was it clear? Did you know the consequences? But new, ignore the employer's actions. That wasn't there before. Then does the claimant meet all four parts of this test? Yes, they do. Then you're guilty of misconduct. So it sounds reasonable. The problem is they're ignoring this allegation by not looking at the actions. So I'll give you an example. Let's say there's an employer who has a productivity problem, and he has a new policy. I'm going to make all my employers work 24 hours straight with no breaks, right? Think of the productivity I'm going to get. So let's walk through this test. An employer terminates X alleging you only work 12-hour shifts, not 24. In 12-hour shift cases, apply the test. Did you willfully violate the clear policy knowing the consequences? Yeah, you did. New, ignore the employer's actions. Wait a second. Labor law says I can't work more than 13 hours, 16 with agreement. I can't work 24 hours straight. They're saying, yeah, but we're not allowed to look at that as part of the test. So the claimant meets all four parts of the test. Therefore, you're guilty of working 60-hour work weeks into an IDI. Why? Because they took this employer's conduct as not a relevant consideration from the last slide. They shoved it into the misconduct test to all of a sudden alter the very nature of the test. So your employer can make illegal policies, but they're not allowed to look at it because, sorry, the test and precedent says we can't look there. But the EI Act says you have to look at whether the employer acts contrary to law, right? They're engineering a new test that overrides what the Act does. And that
Well,
is a
and
logic.
it gives the employer, now they can tell you what kind of medical treatments you need to have. Now they have even more control over you. I look at this actually. A more blatant example of sexual misconduct is like, so if your employer keeps sexually harassing you and you finally kick them in the balls under this, You're
Yep,
the problem, and you're
of course.
denied.
And they're not allowed. Like, by structuring a change to the misconduct test under the guise of precedent, they've made it impossible, right? Because this test must be followed in this way. And if you look at what the employer's actions were, you're now violating federal court precedent that says you're not allowed to look at that. So they've made it impossible for decision makers to actually consider whether the employer acted contrary to law, right? Because now they're saying you're violating federal precedent. You can't look at those questions. So if the decision makers in EI aren't thinking this through themselves and they're just hitting a button to insert a template, they're not even considering what it is they're doing. So are they responsible? I mean, we're responsible for our actions, but if they're being put into this decision-making process that engineers out and forces them to break the law, then, I mean, who's really responsible? I would argue that the process of engineers are the ones responsible, not the EI decision makers. And here's the circular reasoning. What they're saying, in effect, is we cannot consider your employer's unlawful actions. Why? Well, because you allegedly committed misconduct. And you're saying, wait, the only reason I'm supposedly guilty of misconduct is because my employer broke the law. Right? What they're doing is they're determining your guilt in alleged misconduct on the employer's unlawful actions, while simultaneously saying, hey, because you're guilty, we can now skip the statutory requirement to investigate whether or not your employer broke the law. It's circular reasoning.
Well,
they're using the cover of precedent.
And it ensures that the person applying for EI is always the problem.
Absolutely, and it's
so it puts that guilt on the
important.
guilt on the employee right off the bat. You're the problem. You're the problem. Yeah.
All of that is based on the M for misconduct and your record of employment, which is arguably a criminal code offense to begin with. And the precedent is so pernicious because we have people that were granted EI by the tribunal. We had a few tribunal members who actually gave honest decisions. The EI Commission appealed that and had it overturned. Why? Because the decision maker who granted them EI did not follow precedent. They were not supposed to look at whether the employer broke the law. They did. So now they actually took the money back out of a woman's bank account. She already spent it on rent, and they're taking back like 45 weeks of pay. Why? Because the EI decision maker violated federal court precedent by looking at whether the law was broken. It's so egregious.
It is egregious, and it's reminding me too of the reinforcement of these collusions between industry and the government that are here, either through the green new stuff that they're doing, which is all subsidies, to immigration, which is all subsidized for many reasons. The votes being one, there's just a very strong collusion. AHS said employers had to do this, and so employers did this. And what did they get? They got some subsidies for whatever they lost, and some grants to keep going. The collusion is there, and we talked about we didn't talk about, but something that comes to mind is when it was clear that we need to have the separation of church and state. It's clear to me that now the real malevolence is the collusion of private and then public industry, that there has to be a separation from the private and the public. So where does this leave us then? This is okay. One, this is a lot, and my feeling now, although I'm not a big fan of the government anyway, is you're walking into that EI office and the deck is stacked against you.
Yep.
You are the problem. There's precedent saying you're clearly the problem already. We've already said that the employers there is no retribution for the employers anywhere in this standing. We've appointed the people who are deciding this, and not only that, we've told them, here's the templates for making your decisions.
Yeah. Can I
Okay.
show you one more? I would like to show one more template thing before we get to the hearing. This
Okay.
is a really
Let's do it.
important one too.
Okay.
This is called reverse engineering. So as a baseline, there was a case decided in 1965 called KVP, and it came out with this ruling that if a rule is unilaterally introduced by the company and not subsequently agreed to by the union, then this new rule, this new policy must satisfy 6 prerequisites. We're just highlighting 2. This new policy must not be inconsistent with the contract, and it must not be unreasonable. And that includes unlawful, right? If something on its face breaks the law, then it's unreasonable. So that's been around since 65. In 2013, our
Okay.
Supreme Court made that binding across the whole country, saying any rule or policy unilaterally imposed by an employer and not agreed to by the union must be both consistent with the collective agreement and be reasonable. That's called KVP. So now what I want to
Okay.
do is show how they reverse engineered. Let me switch to slide 18.
I'd
I
like
want
to
to show how
get
they
that.
reverse engineered.
Yeah. Yeah. Okay.
Because this is egregious. They've made it clear that if you reverse engineer decisions, uh, your decision is automatically unreasonable. So can I share my screen? I want to show one more thing. I'm just going to show the templates for
Yeah.
KVP.
It should
I'm
be
to
still
share.
shareable there.
Yep, I have it up. I think you have to bring it up into the
There we
stage.
go. Yep. Oh, I gotta remove this one. Add that one. How's that? Woo!
Good. So you can
Fractals.
now see. So I'm
You
going to
just
show
show.
some templates.
Okay.
So we've looked
I'm just trying to
at
get the link up
what
for these
KVP is,
two.
right? It is a test.
Okay.
So we've looked at KVP. KVP is a series of tests you have to look at when they're enforcing a new policy by fiat. And it cannot break your contract, and it cannot violate the law. So they had templates. So I'm looking here from January 22 to December 24. All EI decisions that have KVP and either unilaterally impose or unilaterally bring in, and even if the union disagrees. And there are many templates. I'm just picking this one for example. So here's an example. In a unionized setting, an employer may unilaterally bring in new policies or rules, even if the union disagrees. An employer can do this in what is generally known as a KVP test. The test arises out of Arbitrator Robinson's decision in Reese Sawmill Lumber Union versus KVP.
Holy
In a
cow.
unionized setting, an employer may unilaterally bring in if disagrees, known as KVP test. The test arises out of Arbitrator Robinson. Don't tell me that time after time, someone wrote the exact same series of sentences and paragraphs with the same wording over and over. They knew they were going to get caught, so sometimes they put unilaterally impose, sometimes they put unilaterally bring in. So see, they just changed one word. They all say under Arbitrator Robinson's decision under KVP test. This is a multi-paragraph. I mean, here's what's so egregious about this. Anytime someone said my employer brought in a new policy, they had a template that said, yeah, but KVP gives them that right. So now what happens when people say, wait, I read KVP. KVP says you cannot implement a policy that violates my contract. They have a different set. This legal test was developed in the context of labor and employment law, and I didn't find it helpful in interpreting the EI Act. That's a very long run-on sentence. KVP has limited relevance to the claimant's case. Because this legal test was developed in the context of, I didn't find it helpful. Right, so these are long run-on sentences. Anytime you say can't impose a policy, yeah, KVP gives us that right with a template. Anytime someone says, yeah, but the test says you have to look at whether they broke the contract. Sorry, that test isn't helpful in this circumstances. And they had the same thing in footnotes, right? So there's a long sentence called, this is why the KVP test does not apply in misconduct cases. It was footnote 2. In this case, it was footnote 12. In this case, it was footnote 14. They're picking and choosing the templates they need to get the outcome they are looking for, which is denying EI, even though the reasons in those templates totally contradict each other. And we've proven how sometimes it was the same decision maker handling 2 cases in the same month, and they chose the opposite template for the 2 people in front of them. So here's the last thing. I just want to show an analysis. From 2021 to 2024, that's 3 years, right? That's the mandate period. KVP was mentioned 24 times. I'm going to go to decision, appeal dismissed, and belief for appeal refused. This is denial. The search. Guess what? 24 times. Every time KVP appeared in a template, it always denied the decision. Every single 100% of the time, they picked the template that gave them the outcome they were looking for, instead of dealing with the facts on the case. Don't tell me these long run-on multi-paragraph sentences that cite the same thing over and over are random people, right? So that's. I just wanted to leave that context for.
And two outcomes again. People are being denied insurance that they paid for, that they mandatorily have to pay for when they should be eligible, and 2, that gives the employer even more power. And it looks like the unions are not fighting that either.
No, because we've proven those same templates, those same 5 cases were brought to the union, and they said, we're not going to defend you because we already know you're going to lose out.
Yeah, no, interesting.
And it's the human cost and the cost on the system, right? My uncle worked for 30 years. If they paid him out 45 weeks of EI, they would pay him out less than what he actually put into it over 30 years. Instead, they're saying, no, we're going to fight you. Bath of Napkin, they've spent $300,000 in our case, just in our case alone, because we had 4 tribunal cases, we've had 3 hearings, we've had multiple denials. They spent $300,000 denying us something he prepaid into. If they just gave it to him, it cost them nothing. And here's the irony. They actually, in our first case, said it's not fair that the taxpayers pay for your EI if the employer broke the law. We showed that didn't happen. They came back and made the same argument again and said, even if your employer broke the law, it's not fair for the taxpayers to pay it. And it's like, but they don't. We showed the actual parliament that in 1990, the taxpayers stopped paying for it. And they're saying,
To me, it's unreal. I find that there's this sort of bureaucratic vein through both the public and the private sector. Well, they'll spend $250 on some bureaucratic mechanism to save $150 on possibly $150 on a false pair of work boots or something like that. You know, it's become almost ludicrous to see what they'll spend, but then again, you know why I get back to this? You know what bureaucrats make? Bureaucracy. Do you know what legislators make? Laws.
Legislation.
And now we're drowning in it. So it's interesting to me. I would like to know, on a personal note, if you don't mind me asking, so up to this point, so we haven't even gotten into the case yet. How much time do you think you spent, just rounded up to the 100, in time between you and your uncle on just the research part of this, with your FOIPing and looking at things and reading case law?
It's close to
Impressive.
3,000 hours. We were at 2,500 hours when we
Brutal.
started our PR case. And we spent about 500 hours in the last 6 months doing podcasts and answering emails and blog posts. But it was 2,500 hours for the research and the filings. Because this is our 5th case. We had 4 tribunal cases plus a federal court of appeal case. I mean, we had
Brutal.
180 pages of arguments. Here's just a brief example. The Attorney General responded and said, that's way too long. You have to reduce it to 30 pages. The judge agreed. So we were forced to chop 80% of our arguments out with the understanding that we get to present it at oral argument. Well, 6 weeks ago, the Attorney General sent an email to the judge saying, by the way, Your Honor, 2 days for the hearing, which everybody agreed to last summer, is a waste of the court's time. Every other EI case was done in 2 hours, so you have to give him 2 hours too. And the judge agreed. So our 2-day hearing that nobody had a problem with until our arguments were on the record, all of a sudden, no, you can't put them in writing because that's too long, and you can't have your long hearing either because that's too long. So we had to send a very strongly worded letter to the judge saying this is procedural abuse. The Supreme Court has said if you do this, your case will automatically be overturned. And he backed down and gave us the minimum possible time increase from 2 hours to 3 hours. So we now have 90 minutes to present a case that it was well known would take 2 days to present. And nobody cared about the 2 days until they had our 180 pages of arguments and knew what we were going to be saying. We've been facing this sort of thing all the way through.
So back to my new favorite saying, there is no law that they won't make, and there's no law that they won't break. So, okay, so I just want to point out, if you paid yourself $25 an hour for 2,000 hours, it's $50,000. So I want to put two things. So before we carry on to the case law, the personal time it takes away from your family to fight this for you and Dale, the stress, but then time is money. There's a financial cost to you and your family for this, right? And that's a low ball.
Yeah, I'm grateful there's been a lot of divine providence in this situation. I had the time. I'm single. Right now, I don't have a wife and children, so I don't have to deal with... I'll put it this way. I have the freedom to put the time into this. And I have family who loves me and supports me that have their own home businesses, so I can pick my hours. I just wanted to put that as a book written by the Supreme Court Justice of the United States. It's a fascinating book. It came out about 1.5 years ago, and he tried to quantify how much law is there that has criminal sanctions, and they did a massive study countrywide, and they could not establish how much law there was. So he went through chapter by chapter by chapter, showing how agencies are given the authority to write regulations that have the force of law, but they're not law. And then they're brought into their own tribunals with their own judges, and they execute their own sentences. So they make the law, they decide the law, they enforce the law, and they determine whether or not you're guilty. So it's a fascinating book coming from the Chief Justice, not the Chief, but one of the justices on the Supreme Court.
I'd like to also plug another book that's called The Rule of Nobody by Philip Howard. It's great no matter what country you're in, and it's kind of one of those same things. Is like we're so drowned in. It's almost that idea of safety third too, where you're so focused on tick boxing, that making sure you're safe that you forget to look up and there's a crane over top of you, that sort of thing. It's like we're so worried about tick boxing, making sure that our old folks eat 4 different colors of food and make sure they eat every 13 hours. We're waking them up and now they're irritable and the best part of their lives is being missed, And he also, Philip Howard also wrote a book called Life Without Lawyers, which is also exceptional.
Nice.
Yeah. So there's 2 plugs. Let's get into your case here, Matt.
Yeah. So to go back to your last question, I'm grateful that I've had family that's given me the ability to pick my own hours and my own time to support myself, or I would not be able to have done this. And I have an uncle who's willing to fight this tooth and nail. It doesn't matter. He's willing to lose his home if that's what it takes to be able to put this on the record, to force the courts to have to deal with it. And they're in an unenviable position, right? Because the basis of our case is a series of process engineerings that broke the law and forced decision makers to break the law. They have to make a choice. They're either going to have to rule the government did in fact do that, or they're going to have to say all of the process engineering we hired is not only acceptable, it's required precedent going forward.
Yeah.
I have no idea what they're going to decide. I wouldn't want to be them, right? They had nothing to do with this, but they're now being asked to decide what is going to be the premium precedent case for EI for decades to come. That either this sort of engineering must be followed, or they can't be followed and the government broke the law. Force people to break the law for them.
Well, and you wonder too, like it's a real spotlight on the shoddy work done before, template or not, the fact that you've been appointed for large money to do such an important job and you're cutting and pasting.
Yeah. And their job is threatened if they don't use these cut and paste templates. And again, I can point to specific cases where tribunal members avoided the templates. They had to use them, but he explained around it. Every time he put in a paragraph with a template, he explained how it didn't apply. And he went all the way through and he was honest. He gave someone EI. It's a precedent-setting case. Her name is AL. Her case was cited about 150 times. The EI Commission appealed it, and the tribunal did something they've never done before. They applied a whole board of appeal members to overturn the decision. And they said that because he didn't follow the templates and he self-contradicted himself, that his decision has to be thrown out and cannot be used as precedent.
It reminds me of when Canada got that special rapporteur that was our Prime Minister's uncle to investigate the Prime Minister. It's like when all else fails and you're backed into a corner to do the right thing and speak the truth and do your job, make something up. Yeah. So then from all of this, you did this research. So let's backtrack and give the story again. So family member of yours, Dale, he's been a worker for 3 decades, good worker, mandates come along. He says, no, I want to control my own body. I don't, blah, blah, blah. I'm going to apply for EI. I've been paying into it for 3 decades. I'm a Canadian. This is what I love about Canada, is its social safety net. Goes in, nope, you don't get it. And we've already decided you don't get it, and we've already decided everything. So you guys dig into it. It sounds like you've done almost 3,000 hours of research to a huge cost to you, your family, the stress levels, good on ya. But what's it for? I mean, knowledge is not nothing without it coming to fruition.
Yeah.
And what it's come to, and something that really drew me to talking to you, is the fact that you're now putting it into practice by representing yourself pro se, which means without a lawyer, you're doing it yourself in these tribunals. So just because it's not a criminal court doesn't mean it's not a legal thing, that you are representing yourself, you're doing your own briefs, you're looking at past case law, precedents, and you're getting it together, and you've gone to the tribunal, you said 3 times, I think it was, or was it 4?
We had 4 cases. We didn't have 4 hearings, though. Some of them were summary. In other words, we had to submit written submissions, but we didn't argue in person. But we had 4 different tribunal cases.
So you wrote your own
Yeah.
legal submissions. Of course, we've already found out that there's no law they won't make, no law they won't break, and everybody can invent a special rapporteur. So they've been put out, but now you have a big one coming up. Tell me about it. And also, I just want to say, man, I love you. Because I can't find a lawyer to take, which is such a no-brain case, easy money, East Old account in Alberta. Obviously, you guys had a hard time too. It's clear that the lawyers no longer represent the people, that their professional body has become perverted and maybe overtaken. So you decided to do it yourself. That's not nothing. The law is not written in English.
Yeah, it's a lot of work to try and not understand just what happened, but how and why it happened. And
Okay.
once we understood what they were doing, we said we can't stop. Like, it's a real risk.
Mm-hmm.
From an EI perspective, they're used to people saying you made a mistake in my case, fix it. They're
Mm-hmm.
not used to someone coming with a challenge to the entire system itself. And
Mm-hmm.
it's a huge risk, but it backs them into a very difficult decision where they either have to defend something that's clearly illegal, or they're going to
Mm-hmm.
have to call out the illegality and expose what the government did. There is no middle ground. So how they're going to decide this, we don't know. Our goal is to just make a paper trail as long and as clear as possible, highlighting all the abuses. And the only thing we're asking is if this is important to Canadians, put your voice in the record.
Mm-hmm.
It takes 1 minute to apply for a hearing. They'll put the
Mm-hmm.
links in the chat. Um, Literally 1 minute. Put in your name and email address. They'll send you a link to watch the hearing. And if you have the time, send public interest letters. They're pre-written letters that deal with the legal issues at hand, that get sent to the courts, to the Attorney General, to the leadership at Employment Canada, just letting them know that I'm a Canadian citizen, I'm concerned by this, and I really expect that you guys would uphold the law. Please do so.
Mm-hmm.
And there's a form you can add if you were denied EI yourself, then you can actually put your own story into this letter and include it in the envelope
Mm-hmm.
as it goes to Canada Post, which is important because that means when the judges are making their decision, they're not just looking at us. They're having the story of hundreds of thousands of Canadians being added to the record saying, yeah, this happened to me too. It wasn't just an isolated issue. And it gives you a chance as a Canadian to speak up and put yourself into the story.
Right, right. So let's back up before we get to the public interest in the letters and go to the case that's presented. You're presenting here on the 25th, and then let's end up show. I'd like to be able to for you to show and actually lay out that process of the public interest letters and the template and how it goes in. Now, I also want to point out with those public interest letters, well, I'll do that then. Talk about the case that's coming up, and then we'll get to what people can do. How about that? We'll end with that.
Sure.
Okay? Yeah?
Sure. So we now have a case on the 25th. It's taken a long time to get here. I'm not allowed to present. It has to be my uncle because I'm not a registered lawyer. They will not allow me to address the court.
Okay.
We do have a pending request for me to sit next to him so I can help him look up page numbers and keep notes. We don't know if they'll accept that or not, but we've made the request. And again, we only have 90 minutes. I already explained the shenanigans that went on to reduce 2 days to 90 minutes of arguments. So we have to rewrite. There's no possible way that we can address 15 errors, 3 of which have never been addressed by any court ever before. Mm-hmm. And one of them is a RISO analysis of a large section of the Employment Insurance Act. So we're being forced into a spot where we have to pre-write, basically a summary. Like, we have less time than we've been on this Zoom call or StreamYard, I guess. Sorry, never been on it before. We're supposed to prevent a very complex issue. So we have no choice but to rewrite as much as we can fit into about 70 minutes. He's going to have to read it because I can't address the court. And then we have to reserve some time to respond, because we have no idea what they're going to say, but they actually dedicated a team of 2 lawyers plus their paralegals. So 5 or 6 people were assigned to our case full-time for 6 months.
Holy.
So we have to reserve some of our time to respond to them. And the Chief Justice was quite upset by our very strongly worded email saying this is procedurally unfair. So he wore it. I'll give him credit. He wore the decision. He actually put in the order for our hearing, saying the hearing may not exceed 3 hours, and this is by order of the Chief Justice. So the judges hearing our case cannot give us more time, or they are violating a direct ruling from the Chief Justice of the Federal Court of Appeal. But by doing so, he put that upon himself. So if we lose this, we can now appeal the egregious procedural fairness issues that have happened in this case and include everything that's happened along the way. There's a lot more I haven't exposed that I don't want to unless we're forced to appeal to the Supreme Court. But these sort of issues we've looked at the tribunal have been happening in the courts too.
Mm-hmm.
So that's what we're looking at, is a 70 roughly minute pre-written speech from my uncle. I may or may not be sitting next to him to help him find. We have over 3,000 pages of submissions.
I have an idea. I have an idea around that might be helpful for you, that we can talk after we're done. So
Sure.
Stay on the line once we're done. Okay. Yeah.
Yep.
So then you go in, you've gone from 2 days to now 90 minutes. You have to, this is what's so bizarre to me. If you want to get at the truth of something, you don't lay down a time limit, especially when it's a complex issue. It's like watching Parliament. It does my head in. It's like, okay, you've got your 3 minutes. Go. Let's talk about how AI is going to, collapse the whole employment industry. 2 minutes. Go. And everybody's got their punchy memes or whatever. It's like, this is very complex. I feel bad. It must be nerve-wracking to be there with the judges and the lawyers. And then after this isn't even the last step. There's more to come that they can do to you or you can do to them.
Absolutely. This is the Federal Court of Appeal. Because we've already highlighted procedural unfairness, if we get a 3-0 decision against us, we can make a petition to have our case reheard by all, I think it's 9 judges of the Federal Court of Appeal. And again, it's very rare they grant that, but because we've highlighted so many procedural unfairness issues and they've doubled down instead of listening to us, we actually have grounds to appeal. And if we get a split decision, we're not done yet, because I guarantee you, if we get a 2-1 decision in our favor, there's no way the federal government lets this stand. We've already shown that every time they've lost, they've appealed it to reverse the precedent. They can't possibly let a decision like this stand against them, right? So this case is going to the Supreme Court, even though they've never taken it before. And if it's 2-1 in their favor, we're not going to stop. We're not going to let them set this sort of precedent that requires these shenanigans in the future. So you can just pre-write decisions and force people to break the law.
Yeah,
we're not done until the Supreme Court says no twice. That's our mentality on this.
Yeah.
And we have no idea what happens between now and then. That's up to the judges, and we're just praying we have judges that have the courage to do the right thing.
Yeah. Yeah, and if not, I think that as much as sometimes I don't agree with it, there is a court of a public opinion, which is why you're doing these shows and why people like myself and David and Gilbert have wanted to, and I'm sure others have wanted to shine a light on this. And I do hope that more people pick it up. But what I've found from my court case, and maybe you run into this, is people have a hard time understanding why it's a big deal. Or if they do, I think most people acknowledge that the rule of law is dead. They have a hard time. Yeah, they have a hard time getting behind it because there's been so much apathy. And I think the third thing is people are lazy.
Yeah, I definitely had some funny papers I wrote about that when I was in school.
Yeah, because I know
it's hard to break.
Sorry,
it's hard to break through that. It's hard to break through that that conditioning that we've had from our education system in the last 3 or 4 decades.
Yeah, and that socialization of being Canadian means being nice, which means doing what you're told.
Yeah. And if not, then you're going to be socially ostracized and mocked and ridiculed and self-censored.
Yeah, I'm sure you've faced a bit of that too. Let's go through the public interest letters. So these are a way, from what I understand, people can support you within the process. So it's not like putting up a Facebook post, or it's not like, just writing a letter to whom it may concern, these letters actually go to that legislative body. In this case, that is the federal court.
Of appeal.
Yeah. Is
So
it this one?
I got my screen.
Or is it the other one?
No, it's the other one.
This one?
Yeah.
There you go.
That's it. Yep.
Okay.
So
you go on your website
I'm
here.
almost done. Yep. So there's a short 2-minute clip. The first link is court files and presentations, which has links to all the documents we've submitted to the court, links to our channels, and then various presentations where we walk through the case. We have a 5-hour in-depth. I mean, if people really want to understand it, it takes that long. And then we have a hearing at similar to what we're doing. And I divided it up into small clips, like 10 to 15-minute clips for each section. So that if someone doesn't have a few hours to watch a long form, they can just pick censorship, they can pick templates, and
Okay.
very next one down. Again, we're going to have updated instructions up here
Okay.
in a couple days, but the letters themselves have not changed. So we have pre-written letters. There's 8 letters that are going to 3 places. So it has to go to the current court, that's the Federal Court of Appeal. Then the supervisory court is where would you appeal if you don't get a good decision, that's the Supreme Court. So these letters have to get sent to both the Federal Court of Appeal and the Supreme Court. At the Justice Department, it has to go to 2 people. It goes to the Attorney General, because the Attorney General is automatically defending any case where the government's actions are being challenged. And then the litigation director is the person in the AG's office that's responsible for determining what do we argue and how do we argue cases where the government is on trial for something. So this is the office that would determine who do I assign to the case, how do we argue the case, what sort of arguments do we make. And at Employment Canada, there's 3 people. There's the Minister of Jobs, formerly the Minister of Employment. There's the Secretary of Labor, and then there's the Ombuds. Right, the Ombuds is a person who looks at fairness issues inside the agency. If you have a complaint about how something was structured, then there's supposed to be an independent arbitrator who looks at what happened and render a decision. Was what happened fair or not? And then we'd like a copy to come to us. Because of all the censorship we face, we have no way of proving how many people send letters. So by sending a letter to us as well, we have a PO box set up. Then it gives us the capacity to count how many letters we have. And we can walk into the court with a big bag and drop it on the table and say, look, we've had 1,000 or 5,000, whatever letters from Canadians across the country who have joined themselves to this case. And then also, if you have a Conservative MP, there's no stamp required for your own MP. If you have a Conservative MP and you're within driving distance, there's a lot that I can't say on a public podcast. I will say this. They are aware of this issue. They are looking at it closely. Because it is still actively in the courts, there's a lot of powers of Parliament they cannot use yet. There are some things they can do. They've made it clear, if you have a Conservative MP, bring in a public interest letter in person. They already have a process up waiting. The issue is what they want to do, they cannot do just because one Canadian raised a complaint. So again, if you have a Conservative MP, doing it in person is a different process, and they are waiting. I can't get into details right now other than just to say that. There are things they want to do that they can't until they recognize the Canadians across the country are waiting. So here is an example of, here's the addresses for everywhere it's going, right? So there's the Federal Court of Appeal, there's the Supreme Court. If you want to send emails, you can, but please do not just do email only, because they do not have to process electronic email the same way. If they get something on paper through Canada Post, there's a process by law they have to follow. with how to handle the requests from the citizens. So it's really important that it comes through Canada Post. It only costs about $8.50 for a 6-pack of stamps. It takes about an hour of time.
Well, and you've already pre-written the letter that somebody can add their bling to, right? Too, you can add your own thing.
Yep.
So to me, looking at this, because I like to lay it out this way too, you've invested 3,000 hours, you and Dale. This would take us, including going to, by doing it by email, printing this off, adding your bling, adding your signature, and probably going to the post office. You could probably do it in a half hour, an hour if you're rural. I mean, that's not much of a cost for us people to get behind you guys on this. Your 3,000 hours to our half hour to an hour. And so I really want to say that again to people. Your investment in helping these people out, which in turn, Dale, by these people I mean Dale and Matt, you're helping out all those Canadians. How many Canadians were denied this?
About 450,000, close to half a million.
Yeah, and so that's 500,000 Canadians you're helping, and that doesn't even include the people like that I knew that knew this came down the post and didn't even show up to EI. I bet you there's another 500,000 that didn't even show up because it was a waste of their time, that had to just leave it and lose their house or move on. So it's easy to see hundreds of thousands of Canadians are affected. Again, I want to say Dale and Matt have committed thousands of hours on their own. All they're asking for, they've even done the work for you. You just got to show up. It's not a huge time commitment. So just asking people, again, to do this. And I can see, I've been on the website here. It's so clearly laid out. You can go to the public interest. I've got it here on the bottom. I've got this, I've got the link right here. You can click the link. You can go there, you can find the letter, you can make it your own, you can do the email, you can print it off, you can sign your name and get it in the mail. Easy.
Thank you.
You guys couldn't
I
have
really
made it
think
easier.
this case will rise and fall. We're trying everything. Our goal was 1 hour and $10. To put more than that, it's diminishing returns. But this case, I believe, will rise or fall depending on how many Canadians join us, because we're asking the courts to look at what the government did and call it out, and if it's just us, it's going to disappear in silence. If they get 5,000 letters, that was our goal. That's 1% of the 500,000 people that were denied. If even 1% of them, if they get 5,000 letters from 100 ridings across the country saying, hey, me too, it's going to be very hard for them to turn what happened into precedent. So again, it's just your name in the top corner.
And it's happening too
Your
much.
signature at the bottom. We do have an attachment for personal impact.
Thank you. This is happening too much.
Say that again.
With
Sorry.
CPP. This is happening too much. Not just with EI. That the idea that we're paying for things that we never get, services and products we never get from this government is one thing. But the other thing is that it's becoming harder and harder to hold them to account, and sometimes it's maybe not even that's for us. I think hopelessness and apathy are the end result of doing nothing.
Well, we're not hopeless. I think people misunderstand just how much authority they have.
Yeah.
It's still in the prosecutor's handbook. Public interest is supposed to be a predominant feature of judges' decision. And prior to World War II, it was done regularly. They have sort of engineered this out to the point where if you have a lawyer, they will tell you not to do public interest letters. But we've had really good success with these because when judges have the courage of knowing the public's behind them. And we have a second letter. If you were affected by EI, then you can put your own story into it, and you can check of the 14 errors we're arguing, which of these errors happened to you too. And these error numbers correlate.
You guys have done a great job at laying this out and then making the public interest part really user friendly.
We're trying, and we appreciate you giving us a chance to get the story out.
Yeah.
The story will be told. The amount of shenanigans we've been facing to get here, right now we can't because of the process, but one day the story will be told about just how much happened behind the scenes for them to try and prevent this information from getting into the record. That's why the shorten your 180 pages of documents to 30 pages. That's why shorten your 2 days of hearings to 90 minutes. They are trying everything they can to prevent this story about how and why this happened from reaching Canadians. All we have to do is say, hey, we know, we're watching, please do the right thing. And it's going to be very difficult for them to try and justify this if they're being watched and they know we support them.
Back to the human side, the whatever happens with the courts aside, every letter sent is a support letter for you guys, right? Like, it's us supporting each other, not just to show the Canadian government or EI or whatever, but also to show Canadians or from Alberta to Ontario that we're still in it together, right? We're still in it together.
It's a huge encouragement. It's a huge encouragement when we get emails from people saying they're with us. And you know what? It gives me, every time I go to the post office box, it's actually a discovery. Post office is curious too. What are all these letters coming in? So it's a chance to actually share with them too. But some days it's one or two, sometimes it might be a lot more, but the Canadians are actually, the Canada Post, they're sort of laughing. Like, so you're saying Canadians are sending letters to the courts and the government about a decision that needs to be changed, and you're saying that was regular practice for the first 100 years of our country? Yeah. And we're reviving it. Why not?
Yep. Why not? Why not?
There are public servants.
So maybe I wanted to spend these next 5 minutes on something sort of outside of this. David and I, but I'll speak for me, particularly right now, my whole channel is about the Human Responsibilities Tribunal. The other side of rights, the balance of it, right? Which is, what is your responsibility to you as an individual, to your community? Because they work in tandem, and now we're rights heavy, right? And so we see people have let go of their responsibility. And I like how you brought up civics before. So there's that part of it that I'd like you to speak to. But then the other part is this human individual self. I talk a lot on my channel about what characteristics do you need to grow and cultivate for you to be a person that can do this. For you to be a person that can invest these type of hours. For you to be a person that can show up at a tribunal against the Goliath and say, you know what, I'm still here, win or lose, and I'm gonna try and cast that stone at least. So two things, like how did you get here, and what would you recommend to people to do, and what's in yourself and Dale that says we're the guys that are gonna do this? What's your character, so people now need a platform or a template in order to get there, right? And I need you to tell them what it is.
I can only speak for ourselves. We're Christians. We believe in providence. The amount of times that I have stumbled across things that were buried that I shouldn't have found, time after time after time again, I can't see that as just being mere. I believe that there's a God who believes in justice, and if you read the Old Testament, injustice is his primary. There's two things he's so angry about: worshiping false gods and being unjust. And over, the idea of people in positions of power misusing their authority for personal gain, something that he strongly objects to, and he says, I will bring retribution myself for it. So I believe it. I've seen his work, in my life. I've seen his work in this case, and I do believe that he can do. If he's going to do this, and he's going to use us to do it, so be it. Someone has to try, right? Jesus had this parable in Luke 18 about a woman who was being abused by a judge, and she kept going back to the judge complaining. And the judge looked at her and said, like, I don't care about your religion, I don't care about your God, I don't care about you. But because she kept going back, the parable says, you know what? The judge finally said, I'm going to give you justice. I don't care about you, but I'm so being worn down by people persisting. I'm just going to get out of my hair and give it to you. So that's our philosophy. We can't stop. We're going to keep pushing this until the Supreme Court says no twice. And we're inviting people, join us. Let's take a stand together, right? They are public servants. We pay their work, their wages. They work for us. Their documents are public record. Let's resurrect what it means to be a citizen, right? Let's resurrect what it means.
Yes, yeah, I like it. Because really what you're saying is let's be in community together where we support each other.
Absolutely. We're not being supported by the system.
No. And that's part of like where Riff Raft comes from. It's build your own life raft. And so this should also tell people you need to make your own preparations for if you become unemployed. You need to have food put away. You need to take care of you and your own, because here's the thing. The government isn't going to help you. They can't even fix the pothole outside your house. They cannot provide health care anymore. They're not going to provide a pension. They're not going to provide EI. So I love what you're doing, but also the learning is we as a community, and hopefully we bond through this, it helps us prepare for the next steps as a community where we're no longer dependent on these corrupt agencies, right? That will make any rule and break any rule. And so, man, I think you've brought a lot to light here. Again, I want to recap telling people that you can do the public interest letters. It's well laid out. It's not a huge time commitment. It helps these guys in their court. It actually goes to court. It may help in something future with government, with the MPs. It brings support to Dale and to Matt, so as they show up, they don't feel so alone, especially against such a big Goliath. It's just a wonderful thing. I'd like to actually know too, if there's any way people, if they feel compelled to, can support you through a GoFundMe or a Give, Send, Go.
We do have a Give, Send, Go on our page. We don't advertise it. We don't want to be seen as asking for money. But if you go to our blog at the bottom, on all the main pages, there is a Give, Send, Go that people can support.
Because I want to reiterate again, even if it was 2,000 hours, but it seems more like 3,000 hours at $25 an hour, that's a $50,000 hit you guys have taken for a guy, Dale, who's trying to get his income back from what he lost 4 years ago after having a 30-year career.
Well, thankfully he did. He got a career job last year. He just passed his probation a few months ago, so he's back in the same sort of income salary bracket he was in for the last 30 years. Unfortunately, it did mean he lost his family home. But I mean, it could be worse, right?
Hear that. Yeah, I'm really sorry to hear that. I'm really sorry to hear that. This has been super enlightening. You've been very generous with your time. That took us a whole 3 hours, and I don't even think we got everything, but I hope we got enough that you feel you got your point across. David and I would love to invite you back mid-March to talk about what happened on the 25th as you gather yourself back up together again. And I really love what you said about, for us it can't always be the outcome either. For us, sometimes it just has to be that we're the people standing in the face of injustice.
Yeah. Doing the right thing for the right thing's sake, I think, is the most important reason to do it, because it's the right thing to do. And if more of us did this, and I think that the pandemic has opened a lot of eyes and people are starting to do it the first time. If the powers that be understood that we understand who we are, we understand how our government works, and we are going to expect you to do what we pay you to do.
Right.
If they saw 1 million Canadians doing that, imagine what would happen.
Right. If anybody wants to contact Matt directly, his contact info is down here. It's J4 as in the number EIM at outlook.com. If you don't get a message from that, is there because there's some stuff going on with your email, isn't there, Matt?
Yeah, there's a lot of censorship. Our emails often get marked as spam or malware, so they don't arrive.
Yeah.
If it's important.
How else can they get a hold of you?
Our phone number is on all of our press releases. I don't put it in emails because just from a technological perspective, email is a postcard. There's no envelope, a little picture of an email in envelope that doesn't exist. Every email is a postcard, and every server, whether it's Bell or Rogers or Microsoft or Google, can and do take the contents of your email and market it. But if you pull up our press release, then our phone number is written in the top corner. You can call me, you can text me. If it's important, we'll move to encrypted channels like Telegram or something like that.
Sure. I want to give your Give Send Go here again. So that's Give Send Go, Justice for, again, the letter EI, Misconduct. I love what you're doing here.
Thank you. I greatly appreciate you giving us an opportunity.
Totally. Stay on the line. I've got an idea for you. For everyone else, we're signing off. Hey, don't wait for the government. Build your own life raft.
Amen.